Rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning and welcome inside and outside this courtroom. Court officer, could you call the case, please?
Morning, Your Honours. This is file KCBC 2023-10, the Specialist Prosecutor versus Januzi, Bahtijari and H.Shala. Thank you.
Thank you. I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office. You have the floor.
Good morning. Tasneem Shahabuddin, Prosecutor for the Specialist Prosecutor's Office. I have with me my colleagues, Prosecutor Josh Hafetz, Associate Prosecutor John Devaney, and behind us, Case Manager Lena Peterson.
Thank you very much. Very well. I turn to the defense, and could you kindly add to your introduction who of your team is participating remotely or is present in the courtroom, and likewise for your client. We start with the defense for Mr. Shala.
Good morning, Your Honour. Toby Cadman, Specialist Counsel for Mr. H.Shala. I'm joined by Co-Counsel John Cubban, Associate Isabella Kiwan, Investigator Admir Berisha, all present in the courtroom, as is Mr. Shala.
Very well, thank you. Then we proceed with the defense for Mr. Januzi.
As Jonathan Rees, King's Counsel for Mr. Januzi, I'm assisted by co-counsel Mr. Hugh Bowden, who's in court, also by team member Mr. Muharremi Halalai, who's also in the front row. We're also assisted today by Ellen Morgan, Zoe Lan, Sally Harms and Lauren Chambers, who are in the row behind Mr. Cadman's team.
Thank you very much, Defense Counsel. And now we turn to the counsel for Mr. Bahtijari. You have the floor.
Good morning to the court and everyone in and around the court. I'm Felicity Gerry. I'm here for Mr. Bahtijari, who is online and available to the court. I'm joined in court by co-counsel Marion Karin and legal associate Uching Leo, and online by Philippa Stafford, Cassandra Lagood and Isma Rijalovic.
Thank you very much. Okay, then we proceed. The panel intends to conduct the hearings today in public session. The panel reminds the parties that if there's any need to go into private session, and for instance to respect the privacy of the accused or to avoid disclosing any confidential information, I expect the parties to seize the panel immediately and then we can decide on it. Yeah. The panel has conveyed today's hearing to discuss and to hear the parties' submissions on various issues pertaining to the plea agreement proceedings. I will first give a procedural background overview in this regard, also for the purposes of the public. On the 21st of October of this year, the panel decided that the trial shall open on the 14th of November of 2024. This is filing 559. And on the 11th of November, the SPO and the defense notified the panel that they were in the final stages of concluding for each of the accused plea agreements. And this is filing 587. On the 12th of November, following the request of the parties, the panel adjourned the commencement of the trial in order to facilitate the completion of the plea agreements. This is filing 593. On the 13th of November, the SPO informed the panel that it entered into plea agreements with Mr. Shala, Mr. Januzi, and Mr. Bahtijari, and disclose said agreements to the panel. And this is filing 596 COR. On the 14th of November, following the disclosure of the plea agreements, the panel granted the request of the parties to suspend all previous set time limits for future filings, with exception of the time limits pertaining to the review of the accused detention. And this is filing 600. On the 29th of November, the panel issued the decisions on matters related to plea proceedings. This is filing 612, and hereafter I will refer to it as the decision on plea proceedings, whereby it ordered the parties to, 1, submit a revised version of each plea agreement, complying with the requirements of Rule 94 of the Rules of Procedure and Evidence before the Kosovo Specialist Chambers, and to file written submissions addressing matters related to sentencing and present any information of evidence on sentencing should they so wish. The panel further ordered the SPO to submit a revised indictment taking into account the terms of the revised plea agreements. And we also decided to convene hearings on plea proceedings today and tomorrow. On Friday, 6 December, the SPO filed its submissions on plea agreements and sentencing, including a revised version of each plea agreement. And on the same day, it also filed a revised indictment as ordered by the panel. Also on the same day, 6 December was a busy day, the Shala defense, the Januzi defense, and the Bahtijari defense filed their respective submissions addressing matters related to sentencing and presenting relevant information and or evidence as requested. On Monday, 9th of December, the SPO submitted a request filing 6-1 asking the panel to reconsider its decision on the plea proceedings, and that decision was decision 612, or in the alternative, grant the SPO to leave to appeal said decision. The Shala defense and the Bahtijari defense responded to the SPO request on 12 and 13 December 2024, respectively, and the Januzi defense indicated it would not file a response, and the SPO indicated that it would not file a reply. Last Friday, 13th of December, the panel issued a decision setting the agenda for today's hearing and ordered the reclassification of Mr. Shala's and Mr. Januzi's revised plea agreements in the interest of the publicity of proceedings. In the same decision, the panel also ruled that Mr. Bahtijari revised plea agreement would not be discussed in the present plea hearings because it still failed to comply with the requirements under Rule 94 of the rules. This is filing 626. On the 16th of December, so last Monday, the parties informed the panel that it reached a new plea agreement with Mr. Bahtijari and submitted said agreement to the panel. This is filing 628. The SPO and Mr. Bahtijari defense submit that the new plea agreement resolves the issues previously raised by the panel and ask the latter, in the interest of advancing the proceedings expeditiously and simultaneously, to consider the new plea agreement and to schedule a plea hearing for Mr. Bahtijari on the 18th of December 2024. And yesterday, the SPO filed a notice to withdraw its request bearing number 621, in which it sought reconsideration of the decision on plea proceedings, or in the alternative, leave to appeal said decision. And this is filing 631. And finally, also yesterday, the SPO submitted a further revised indictment, and this is filing 630. Very well. In light of these procedural developments, the panel will proceed as follows. During the first session, the panel will discuss matters which are of concern to all three accused. Yeah. And will then issue a number of oral orders. After that, we will have two separate sessions to discuss the plea agreements of Mr. Shala, who is kind of hidden in the back, and Mr. Januzi, respectively, with the SPO, to advance to the extent possible with the proceedings. First, from 11 o'clock till 1 o'clock, we will discuss Mr. Shala's plea agreement, which is filing 618 Annex 1, followed by another session after the break from 2:30 till 4:30 to discuss Mr. Januzi's plea agreement, which is filing 618 Annex 2 and filing 632 Annex 1 with the Albanian translation. During the two sessions, the panel will ask Mr. Shala and Mr. Januzi to confirm, pursuant to Rule 94, paragraph 5 under A of the rules, the following. Whether their respective specialist counsel have discussed with Mr. Shala and Mr. Januzi the terms of their respective plea agreements, whether Mr. Shala and, yes, no, Mr. Shala, maybe you could go a little bit more to the right. Yes, then I can see you. It's much better. Thank you. Whether Mr. Shala and Mr. Januzi understand the terms of their respective plea agreements. Third, whether Mr. Shala and Mr. Januzi confirm the admission of the facts in respect of the charges contained in their respective plea agreements. Whether Mr. Shala and Mr. Januzi have agreed to the respective plea agreements voluntarily, without threats or coercion, and whether Mr. Shala and Mr. Januzi understand the consequences of their respective plea agreements and waive the right to be tried under the ordinary trial procedure. The panel will further ask Mr. Shala and Mr. Januzi to confirm that they wish to change the initial plea and enter a guilty plea for counts 1 and 2 of the revised indictment of 6 December 2024, and I will come back to the status of this indictment later. The panel will also give the opportunity to the SPO, the Shala defense, and the Januzi defense to make additional oral submissions on sentencing, in addition to the ones already received in writing, as well as on any other matter relevant to the plea proceedings. The panel will further give the opportunity to Mr. Shala and to Mr. Januzi, should they so wish, to make a statement regarding the plea proceedings, including on the matters of guilt and sentencing. Very well.
Your Honour, can I just mention one matter?
Of course.
Your Honour said that later today you intend to ask Mr. Januzi if he wishes to change his plea by reference to the revised indictment that was submitted on the 6th of December. In fact, it should be the further revised indictment that's used for these purposes as submitted yesterday.
Thank you, Defence Counsel. I will get back to to the status, as I just said, of this indictment, yeah? And then we can further discuss it. I noted your observation. Very well. Let us now turn to the preliminary matters. At the outset, the panel takes note of the SPO's withdrawal of its request bearing number 621, in which it sought reconsideration of the decision on plea proceedings, or in the alternative, leave to appeal said decision, and accordingly will not address it further. The panel also informs the parties that even though the SPOs withdrew its request, considering its late notice together with other late submissions, the panel will not issue a decision on the plea agreements at the end of this hearing, which will also continue tomorrow. A written decision on whether the panel approves the plea agreements will be issued in due course following today and tomorrow's hearing, as well as the panel's assessment of whether additional written submissions or hearings are required. The panel finally informs the parties that an order on the submission of further revised plea agreements will also be issued in due course. Next, as regards the SPO submission on a further revised indictment, which is the filing bearing number 630 Annex 1, the panel notes that said revised document was notified yesterday at 15 hours 24. In this light, the panel will not consider it for the purpose of this hearing, given that it was not submitted sufficiently in advance to allow the panel adequate time for properly review and consideration. The panel will consider it in due course. Therefore, the panel finds that the indictment that is currently operative in this case, in line with the panel's instructions at paragraphs 23 and 30b of the decision bearing number 612, is the one submitted by the SPO on the 6th December 2024, with filing bearing number 619 Annex 1. And we will refer to it as... Wait, I'm still talking. You cannot interrupt me. Thereafter, we will refer to it as the 6th December 2024 indictment. Before proceeding, and I will also give you the floor, Mr. Januzi, Mr. Rees, don't worry, I will give you the floor. Before proceeding, we ask, however, the parties to explain why paragraphs 11 and 19 of the 6th December 2024 indictment were deleted in the indictment submitted yesterday, which is filing 630 Annex 1, and whether, and if it does, to what extent said deletion affects the charges as pled in the plea agreements. I will first give the floor to... no, I will do it otherwise. This question is there, but I will first give the floor to Mr. Januzi, to Mr. Rees, because he has asked for it, and then I will also give the floor to the other two defense counsels and to the SP.
Yes, I can...
Defense counsel, you have the floor.
So I can answer the first question as to why those paragraphs were deleted very simply. Your Honour ordered that the indictment be revised to reflect the content of the plea agreements. The plea agreements focus solely on intimidation by means of an offer of a benefit. Threat is no part of the plea agreements, neither is fear or concern being caused to the alleged witnesses. The effect on the witnesses is not agreed and has not been proven against Mr. Januzi either. Therefore, once the 6th of December revised indictment was submitted, we raised with the SPO that in our view it did not accord with the order to revise the indictment to reflect the content of the plea agreements. There was then a prolonged period of constructive inter partes correspondence, which resulted eventually in the further revised indictment for the purposes of the plea agreements, which was submitted and dated the 17th of December 2024. It's a document that it is agreed between the parties reflects the plea agreements. It doesn't affect the plea agreement at all because it is consistent with the plea agreement for Mr. Januzi. I'll let my friends deal with the position of Mr. Shala and Mr. Bahtijari. Although I can say this, that it's understood that all parties are in agreement that this reflects the plea agreements across all defendants' cases. As far as the plea agreements go, the agreements were based upon agreed factual bases that are annexed to the plea agreements. You will see in those plea agreements, in the factual written bases, no reference to any consequence of fear or concern on the part of the witnesses. Accordingly, it's our submission that the indictment that is relevant for the purposes of these plea agreements is the agreed revised indictment dated the 17th of December 2024.
I hear your submission, and is there any consequence for the fact that you see that that should be the document we should be using today?
Yes, it is. And you should disregard the earlier revised indictment because that was submitted as the SPO quite fairly and appropriately notified the panel at the time it was submitted that there were ongoing discussions taking place between the parties to reach agreement.
Thank you, Mr. Rees. I will not enter into a discussion with you on this. However, allow me to note that we noted that there were ongoing discussions, and we also note that we received this further revised indictment yesterday late afternoon. Now, so that's for the record.
That is the consequence of much hard work on the part of the prosecution team that sits opposite me, and I commend them for that, for the constructive spirit with which they entered into those discussions. It was the result of much hard work on our part as well to reach that situation. Of course, we wish that we would have been in a position to have reached agreement sooner than we did, but given that the further revised indictment dated the 17th of December reflects the plea agreements, the substance of which the panel has had now for some time, I do nevertheless submit that given the panel's, of course, adequate capacity to digest the content of the plea agreements, that we proceed today with reference to the 17th of December further revised indictment, and the previous revised indictment effectively be set aside.
The last part we already noted, but thank you for this further addition. Thank you. I will give the floor now to Defence Counsel for Mr. Shala.
Your Honour, it's a common position. Certainly, the position as far as Mr. Shala is concerned is that the 6th of December indictment does not properly reflect what is set out in the plea agreement. The amendments that have been made that are now reflected in the 17th of December indictment properly reflect the ongoing inter-parties discussions that have taken place and properly reflect what Mr. Shala has agreed to. It is our position equally that it is the 17th of December indictment that should be proceeded with, not the 6th of December indictment.
Thank you, Defence Counsel.
And I would only add that it is difficult to proceed further with these matters today unless and until the 17th of December indictment is considered by your honours to be the operative indictment for the purpose of these proceedings.
Okay. That's a clear submission. Thank you. Defence Counsel for Mr. Bahtijari, you have the floor.
We agree with the submissions that have been made by Mr. Rees on behalf of Mr. Januzi and by Mr. Cadman on behalf of Mr. Shala. The indictment dated the 17th of December is an indictment on which notice was given, which has been agreed. It is cooperative, it is sensible, it is a sensible resolution of the issues, it properly reflects the evidence, and it properly reflects the plea agreements. As the court has noted, it has had time since yesterday afternoon and has clearly recognised which paragraphs have been deleted. These proceedings should proceed on the indictment for the 17th of December, as we have all agreed and worked very hard to provide it for you for yesterday. I must add that, of course, Mr. Bahtijari's position is that he should be released immediately, so any further delay is of complete prejudice to his position. Thank you.
Thank you, Defence Counsel. Is it your position, Defence Counsel, that the only changes that are made to the further revised indictment are the paragraphs I just mentioned?
No, I was summarising what I was submitting.
Okay, then we are clear on that. Good. The SPO, please. Madam Prosecutor, you have the floor.
We would agree with our colleagues' submissions, our various specialist counsel, regarding how the filing of the further revised indictment came to be. At the time that the SPO filed the 6 December revised indictment, it was our view that it was in line with the panel's earlier decision on the plea proceedings, in that it withdrew count 1 as well as relevant facts and allegations, taking into account the terms of the revised plea agreements. However, we did share that indictment with specialist counsel before making the 6 December filing, which is why in the cover filing for that submission, we noted that there would need to be further discussions in light of specialist counsel's assessment of what the same decision from the panel, the decision on the plea proceedings, required of the further revised indictment. And so those conversations did continue diligently, and we were only able to reach an agreement yesterday, and then we filed the further revised indictment right away. So that's a little bit of the history there. But it is also the strong position of the SPO, in accordance with what my colleagues have said, that the terms of the revised indictment, the further revised indictment, provide no bar here to the acceptance by the panel of the plea agreements from each of the 3 accused, because the plea agreements refer to specific paragraphs and provisions of the amended indictment that was filed under filing number 379 on the 10th of July. And those provisions are not in substance changed at all in either the 6 December revised indictment or in the further revised indictment submitted yesterday. So for the purposes of the plea agreements and and what the parties have agreed to in terms of the counts to which the accused proposed to plead guilty, those aspects of the indictment remain unchanged, and should not have any impact on the ability of the panel to accept the plea agreements or to proceed under the agreements as written for the purposes of today's various hearings. I want to make one further point, which is that Your Honor referred to the 6 December revised indictment as the operative indictment. And I want to note that in submitting both the 6 December revised indictment and the 17 December further revised indictment, the SPO was clear in making a submission that those indictments were only to take effect once the plea agreements had been accepted by the panel for each of the accused and the guilty pleas actually taken, such that we are not put in a position where, for one reason or another, these guilty pleas do not end up resolving the case, and then we are left with a revised indictment that was designed with that end in mind, and then we're put in a position of having to proceed to trial under such an indictment. So I just wanted to make that note with regard to the operative indictment. It's our position that as of today, until the guilty pleas are accepted and we're in a position to move to sentencing, that the operative indictment would remain the 10 July amended indictment.
Thank you, Madam Prosecutor. We will have another round, and I started at my left-hand side, so that's how we will proceed. So I will give again the floor to, if necessary, of course, to the defense counsels. Mr. Rees, would you have anything to add in this respect?
No, it's clear that at the bar, all parties, prosecution and defence, are in accordance, that the indictment that should be considered for the purposes of the plea agreement is the 17th of December 2024 indictment. It reflects accurately the plea agreements. The revised indictment of the 6th of December should be disregarded, and we should proceed in relation to the 17th of December 2024 indictment.
Thank you, Defense Counsel. Defense Counsel for Mr. Shala, Mr. Ketman.
I concur with what Mr. Rees has said and what the SPO has stated. The only thing I would add is that it puts us in a slightly difficult position as to how we proceed with certain decisions not being made. I don't really see how we can proceed with submissions on sentencing as we are required to do until we know a decision has been taken as to whether the plea agreements have been accepted or not, and under what indictment Mr. Shala in particular is going to be asked to enter a plea. So obviously it's a matter for your honours to decide the procedure, but I would certainly urge a decision has to be taken first of all in respect of the matters that have just been discussed before we could really take matters any further.
Thank you, Defense Counsel. Defense Counsel, Mr. Bahtijari.
Thank you. We agree with the submissions that have been made by everyone in the courtroom, and we particularly agree with the submissions made by Mr. Cadman that it does not make sense to proceed until we know the indictment is accepted and the plea agreements are accepted. So we would invite the panel to retire and make a decision on that today, please.
Thank you. The floor is now for Madam Prosecutor.
Thank you. I have a slightly different take and just wish to clarify the position I articulated earlier. We agree that in terms of a revised indictment, we should proceed with the indictment that was filed yesterday. However, because each of the plea agreements refers specifically to the 10 July indictment and provisions and paragraphs contained therein, and because that will not change, and by design will not change, whatever further revised indictments may be required, it's our position that there is no barrier to proceeding today with regard to further clarifying, entering into the colloquies that Your Honor proposed earlier with regard to the plea agreements that have been filed as between the SPO and each of the accused for the purposes of today's proceedings. We can certainly, we can represent that the plea agreement is a complete document that reflects the counts of the indictment to which each of the accused propose to plead guilty, the specific charges, and contain the factual bases that would be needed for Your Honors to be satisfied as to the guilt of each of the accused for those counts. And so in that respect, we do differ as to how we think today should proceed.
Thank you, Madam Prosecutor. If views are sufficiently exchanged, I think it's more important to have everybody's view sufficiently represented here or submitted here. So I don't see anyone else asking the floor on this. Good, very well. I have still 2 oral orders that I would like to issue. And after that, panel will adjourn and we will discuss the issue that is laying before us, and we will come back after that with a ruling. Yeah. See that I see nodding faces, so that's good. Very well. Yes. The first oral order concerns the new plea agreement submitted by the SPO and the Bahtijari defense last Monday on 16 December 2024, which is filing 628, Annex 1. And I have already given the procedural history with regard to this filing. Having reviewed, you cannot hear me?
Not very well over here. It's not very loud. Thank you.
But maybe it helps if you put on the, yeah. Thank you. But the microphone should be off, huh? But we can put the sound louder. Okay, very well. Yes, it's an oral order directed to the Bahtijari defense, so yes, important that you don't miss anything. Very well. Having reviewed the new plea agreement, the panel finds that said agreement complies with the requirements of Rule 94, paragraph 2 of the rules. The panel thus finds it appropriate to schedule a hearing on Thursday, 19 December 2024 at 1 o'clock, subject to any decision the panel may take today with regard to the outstanding question, to discuss Mr. Bahtijari's new plea agreement with the SPO in order to advance to the extent possible with the proceedings. During this hearing, the panel will follow the agenda set out in paragraph 20 of the decision bearing filing number 626. Accordingly, the Bahtijari defense is instructed to indicate whether Mr. Bahtijari intends to make any statement on the plea proceedings, including on the matters of guilt and sentencing, by today, Wednesday, 18 December, at 6 o'clock.
I can answer that now. He doesn't.
Okay. For next time, just allow me to finish my oral. Yeah. I always tell when my oral order has finished. Then for next time, I always say, this concludes my first oral order.
That's very helpful. Thank you very much.
Furthermore, considering the nature of the hearing and the matters to be discussed therein, the panel decides, pursuant to Article 40, paragraph 2 of the law, to hold said hearing in the presence of Mr. Bahtijari. More specifically, the panel finds it appropriate to order Mr. Bahtijari to be present throughout the hearing of Thursday, 19 December 2024, in the courtroom. Finally, in light of the submissions of the new plea agreement and the panel's decision to proceed in discussing its terms with the accused during tomorrow's hearing, the panel finds it appropriate to reclassify as public Mr. Bahtijari's new plea agreement. Accordingly, the panel instructs the registrar to reclassify as public Mr. Bahtijari's new plea agreement as soon as possible, which is filing 628 with Annex 1. And this concludes the panel's first oral ruling. And let me say this, we all speak when we are given the floor. We don't step up and we start talking. We are given the floor and then we proceed talking. There is a second order. The next oral order is on reparations. The panel notes the reference made to reparations in the plea agreements, and that some parties have reserved their rights to make further submissions on this issue. In this regard, the panel recalls that no framework decision regarding victim participation was issued in this case, unlike in case 4 and 5, in order to inform potential victims of their rights under the law and the rules. In order to ensure any rights of any potential victims, and given the specificity of this case, the panel orders the following. As a first step, the victim's participation offer, further referred to as a VPO, should receive and this is subject to our further ruling, the 6 December 2024 indictment, 619 Annex 1, and the confirmation decision of the 2nd of October 2023, filing 8, and the decision on the confirmation of amendments to the indictment of the 8th of July 2024, which is filing 377. And to this end, the panel instructs the registry to make available these filings to the VPO. The VPO is to refrain from disclosing to any person information subject to redactions in the public versions of these filings. Given that the unredacted version of said indictment, the confirmation decision of the 2nd of October, and the decision on the confirmation of amendments to the indictment of the 8th of July 2024 clearly indicate who potential victims might be, the panel orders the SPO to share with the VPO, to the extent available, contact details of such persons, so as to enable the VPO to reach out to them without delay, in coordination with the Witness Protection and Support Office if necessary. Moreover, the SPO should provide the VPO with any other necessary information or recommendation related to the security of the applicants, so that the VPO can exercise its function fully and with due respect to the prevailing security considerations. The VPO should ensure immediate reach out to assist any would-be, because there's no clarity on that, of course, any would-be applicants with the application process. Only in the case there are applicants, the VPO should send a report to the panel, which includes a summary of the collection process of applications, the total number of applications received and the number of applications submitted, the number of direct and indirect victims whose applications have been submitted, and the type of documentation accepted to prove identity, kinship, and guardianship, the type of harm alleged, and the type of documentation accepted to prove such harm, a summary of the protective measures requested, and the VPO recommendations regarding such measure, and a summary of the VPO recommendation of admissibility, indicating the number of applications proposed to be admitted or rejected, with a general description of the reasons for each group. In light of the limited scope of this case, the panel orders the VPO to submit the above report by the 20th of January 2025 and indicate if it can be shared with parties in accordance with Rule 113, paragraph 2 of the rules, so as to enable parties to respond in accordance with Rule 113, paragraph 3 of the rules by the 27th of January of next year. The panel notes that pursuant to Rule 130, paragraph 6 of the rules, applicants may appeal as a right of decision of this panel denying their applications, and such appeals must be submitted before the Court of Appeals panel within 14 days of the decision denying the application. And this concludes the panel's second oral ruling. The panel will now adjourn, take for now a 30 minutes break to deliberate on the outstanding issue, and then we will come back. The hearing is adjourned.
All rise. All rise.
Please be seated. Welcome back. Very well. The panel has deliberated on the outstanding issue, and we will give an oral order. Having considered the submissions of the parties on the matter of the further revised indictment submitted on the 17th of December 2024, the panel decides to maintain its decision not to consider this indictment for the purposes of this hearing. The panel notes that the 3 plea agreements, as they stand, refer to the confirmed indictment of the 10th of July 2024. As a result, the panel finds that there is no impediment to proceed to discuss the terms of the plea agreements on this basis. However, should the parties disagree on the basis I just outlined, the hearing will be adjourned and the panel will issue further instructions in due course. If only one of the defense teams would agree on this basis, the panel will only proceed with that accused. This is the oral order of the panel, and I will give the floor first to the defense, and I propose that they can also liaise with their client. So we give permission for that. And then I will first give the defense teams the floor, and then I will give the floor to the SPO.
All right, can I ask for clarification of one matter? At the outset today, Your Honour, when you went through how you envisaged the procedure to take place, you referred to the previous order F00626 and the content of paragraph 20 thereof, in which you reminded us that the panel will go through with each relevant defendant the questions that relate to rules 94.5a and d of the rules, and then added that you would then ask them to confirm how they would plead by reference to the revised indictment of the 6th of December. Do I take it from your Honour's order that you no longer, the panel no longer intends to ask the defendant whether how they intend to plead by reference to the revised indictment dated the 6th of December, and if that's right, whether Your Honour intends the panel to ask the question as to how they intend to plead by reference to the specific paragraphs in the indictment as amended in July of this year, or simply not ask that question at all?
Mr. Rees, would there be a preference of the defense?
Preference of the defence would be for, if that question is to be asked, it's to be asked by reference to the 17th of December, further revised indictment.
That's clear. It is my understanding that we will, or it should be the understanding that we will proceed on the basis of the plea agreements, yeah, that you have submitted to the panel. On that basis we will proceed, and to the reference therein with a view to the questions we will be asking.
So, again, for clarification purposes, do I take it that Your Honour therefore does not intend the panel to ask any of the defendants how they intend to plead by reference to an indictment?
I will tell you how we will proceed, that we will ask these questions based on the plea agreement you have submitted to us. The questions you just said, we are going to ask them to your client based on the plea agreements as they are now submitted to the parties with reference to the 10th of July 2024.
And the specific paragraphs, and only those paragraphs that
Of
are
course,
within, that are
but
within the July indictment.
Defense Counsel, it is in no way the intention of this panel to change anything during this hearing when asking questions with regard to what you have agreed with the SPO. So if in paragraph 5 of your plea agreement, on behalf of your client, you refer to paragraphs 8 and 9 and all the further paragraphs, that is what we are going to mention.
Yes.
I'm not going to
No
mention
other
12. I'm not going to mention paragraph 19. If that's, it's very clear that we are not going to refer to that. And if we are going to refer to count 2 and 3 of the indictment, the confirmed indictment of the 10th of July of 2024, which are in the revised indictment and in the further revised indictment, we are 1 and 2. Yeah, it's still those counts. Yeah? We are not changing anything. So we would be saying 2 and 3, and you would know that in the revised and the further revised, that would be 1 and 2. Yeah? So there is no intention on this side to change anything in that regard.
No, I understood. And then, for my part, we're in a position to proceed.
You are in a position to proceed?
Yes.
Thank you, Defense Counsel. Then I give the floor to the Defense Counsel for Mr. Shala. And Mr. Ketman, you have the floor.
Well, Mr. Rees has asked a question that I would have asked. So as long as what's being put to Mr. Shala is what's contained in the plea agreement, and that's what he's being asked to confirm, then we are certainly ready to proceed.
Thank you very much. Then we turn to Defense Counsel for Mr. Bahtijari. You have the floor.
Yes, on behalf of Mr. Bahtijari, we are in a position to proceed, and if he is well enough and it is possible, we would invite the court for him to be here this afternoon, as we understand that nobody's submissions will take the time that you have allowed, so we may have time to deal with his case as well today. Thank you.
Thank you for your submissions, Defense Counsel. Madam Prosecutor, you have the floor.
Based on the proposal to proceed on the basis of the plea agreements and what is contained within the 4 corners of the plea agreements, it is still our position that we should proceed today as well with any hearings the panel cares to hold today.
Okay. Thank you very much, Madam Prosecutor. So we will proceed with the rest of the hearings as scheduled today, and we will proceed with your client's discussion regarding the plea agreements, Defense Counsel for Mr. Bahtijari, tomorrow. So for now, we're going to adjourn for half an hour. Then we will come back. We will start with the discussion regarding the plea agreement of Mr. Shala. Yeah. The presence of the other defense teams, including their clients here in the courtroom, Mr. Januzi, and by video Mr. Bahtijari, is not required, but of course they may be present here. And that is it for now. We see each other in half an hour. The hearing is adjourned.
All rise. All rise.
Please be seated. Very well. Welcome back. We will now begin with the plea hearing regarding Mr. Shala. And for the record, I will ask who is present for this hearing again, and I will now start with the defense for Mr. Shala. Mr. Ketman, you have the floor. And you can also refer to this morning's presence if that is the case, but I leave it to you.
Thank you, Your Honour. The composition of the defence team for Mr. Shala is the same as this morning. My name is Toby Cadman. I'm Specialist Counsel. Mr. John Cubban, who's Co-Counsel, Ms. Kiewan, Associate, and Mr. Bahtijari, Investigator, and Mr. Shala is present in the courtroom.
Very well, thank you. Then I will proceed with the Specialist Prosecutor's Office, who is present.
Yes, good morning, Your Honor. I'm John Devaney, Associate Prosecutor. To my right is Tasneem Shahabudin, Prosecutor, and to my left is Joshua Hafetz, also Prosecutor. And present behind me is Linda Peterson from our CIMU.
Thank you very much. We also have two other defense teams present. I will first give the floor to the defense for Mr. Januzi, please.
Your Honour, there's no change from representation as per this morning's session.
Thank you very much. And the defense for Mr. Bahtijari. Defense counsel, you have the floor.
The appearances on behalf of Mr. Bahtijari are the same, but Mr. Bahtijari is not here.
Okay.
Thank you.
Very well, we noted that. Yes, then we will proceed. Before we start, I would like to ask the court officer to provide Mr. Shala with copies of the English and the Albanian version of his plea agreement with the SPO, which is filing 618 Annex 1, as well as copies of the English and the Albanian version of the indictment of the 10th of July, filing 379 Annex 1, because that would assist us in some upcoming questions. Yeah? And we might also be receiving it on the screen. Thank you very much. For the record, I note that the plea agreement was entered between Mr. Shala and the SPO on the 4th of December 2024, and that the accused specialist counsel is Toby Cadman. Counsel, can you confirm this?
I can confirm.
Thank you. Mr. Shala, before we begin, you may remain seated. Before we begin, I refer you to the document called Plea Agreement, which has been submitted to the panel as annex to filing 680. And we have provided you with a copy by the court officer. And I ask you to go to page 10. Could you go to page 10? And you see the numbering in the left upper side. Madam Court Clerk, could you please assist Mr. Shala and assist him?
Your Honour, I think the page numbering is different in the Albanian version to the English version.
But I would like to first go to the English version and then to the Albanian version, because in both versions I would like to confirm if that's his signature. Yeah? So we are talking about filing 618, Annex 1, and then page 10. And on the left side, is that your signature, Mr. Shala? Can you put on your microphone?
Yes, it is my signature.
And then could you please go to page 22 of that same document? In the left upper side, is that your signature?
Yes. Po, në shkrimi emër.
Thank you.
Yes, it is my signature.
Thank you. Madam Court Clerk, thank you for your assistance. I see the prosecution standing. You have the floor.
Thank you, Your Honor. I just wanted to note that in addition to the two signatures confirmed by Mr. Shala, on page 10 of the document at paragraph 26 and at page 21 of the document, paragraph 24, continuing from the previous page, there are two additional signatures in case Your Honor wished to confirm those as well.
Thank you, Madam Prosecutor. I think it would be useful to confirm that too. And that means that I will ask Madam Court Clerk if she can again assist Mr. Shala. Mr. Shala, could you please go to page 10 and to the bottom. Is that also your signature?
Paul.
Thank you. And then page 21 of the same document, halfway the page. On the left-hand side,
Paul, scream you.
Yes, it is my signature.
much to both of you. Specialist Counsel. On the same pages we have just been referring to, and that is page 10 and page 11. Is that all? Can you confirm that it both are your signatures?
Yes, Your Honour.
Okay. And then the same exercise for page 21 and 22.
Yes, Your Honour.
Thank you very much. Then that is sorted. Mr. Shala, I will be directing you during this hearing on several occasions to ask you questions. Mr. Shala, as you know, and certain your counsel is aware, the panel may approve the plea agreement as concluded between the SPO and your counsel on your behalf, if it is certified that certain conditions are met. And this is what Rule 94, paragraph 5 of the rules requires the panel to do. Therefore, I will proceed to ask you some questions in order to verify that all conditions as set out in Rule 94, paragraph 5 are met. Do you understand that?
Paul.
Yes.
I will begin with Rule 94, paragraph 5 under A. In the plea agreement signed by you, it is indicated that you have discussed the terms of the plea agreement with your counsel and that you have entered the plea agreement after sufficient consultation with him. And I refer, and I won't read them out, but I refer to paragraphs 19 and 24 and 25 for your counsel. Can you confirm, Mr. Shala, that this is the case?
Paul Vertetos.
Yes, that's correct. I consulted with a lawyer for everything, and we discussed everything.
Mr. Shala, this hearing will take a while. You may remain seated, and only on one occasion, that will be when I will ask you if you will change your plea, I will ask you to stand up. But if you're answering the panel, if you wish, you may remain seated. Yeah? Okay. Then I turn to Rule 94, paragraph 5 under B and C. In this context, I will go through the terms of the plea agreement in order to allow the panel to assess that you understand the terms of the plea agreement, so that you, on the one hand, you understand them, and that, on the other hand, you agree to the terms of the plea agreement. Mr. Shala, do you confirm that you have carefully reviewed with your counsel every part of the plea agreement in a language that you understand, and that you understand the terms of the said agreement as specified in paragraph 24 of the plea agreement?
Yes, I understood it because it was given to me in my language as well.
I will now turn more specifically to Rule 94, paragraph 5 under C, which concerns the facts admitted by you, Mr. Shala, underlying the charges contained in the plea agreement. And I will start with Annex 1 to your plea agreement, which it contains the agreed factual basis. In this agreed factual basis, which is page 12 of filing 618, Annex 1, you have agreed to the following, and I will read it out to you. And I would like you afterwards to confirm if that is the case. The defendant, and for you, it's page 23 of the plea agreement that was given to you, if you want to follow it also in reading. And for the record, the agreed factual basis in English is at page 12, and in the Albanian version, it's at page 23. Have you it in front of you, Mr. Shala? No? Madame Court Clerk, can you assist?
Okay.
Mr. Shala, can you please switch off your microphone? And Mr. Shala, when you want to talk to the panel, please switch on your microphone, because if not, the translation will not come to us. Shall we agree on that? Yeah, but then if you want me to understand you, you have to put on the microphone.
Patjetër të parë,
Certainly, I just tend to forget.
It's just that I'm very eager to hear what you're saying. Very well, I will read out what has been agreed by you with the Specialist Prosecutor's Office. The defendant, H.Shala, accepts that he was part of a group which sought to induce witness 1 to refrain from giving evidence before the Kosovo Specialist Chambers through the promise of a benefit. In particular, members of the group acting at the direction of the defendant H.Shala approached witness 1 at his home on 5 and 12 April 2023, respectively. During the 5 April 2023 approach, Ismet Bahtijari told witness 1 that he should withdraw his testimony before the Kosovo Specialist Chambers. During the 12 April 2023 approach, Januzi followed up on the first approach and relayed to witness 1 an offer that the defendant, H.Shala, and others would help him if he withdrew his testimony. Before and after each of the 5 and 12 April 2023 approaches, the defendant, H.Shala, communicated and coordinated with other group members regarding their interactions with witness 1. Mr. Shala, do you confirm your agreement on the agreed factual basis as I just read it out to you?
po,
Yes.
I will proceed now to read out, because paragraph 5 of the plea agreement refers to them, paragraphs 8 and 9, 11, 14 till 18, and 24, little I, under I, double little I, and 3 double little I, of the confirmed indictment of 10 July 2024, as referred to in the plea agreement. And then, for ease of reference, Mr. Shala, the document with the number 379, yes, I will start with reading paragraph 8. Do you have in front of you, Mr. Shala, paragraph 8?
Po.
Very well. I will read it out for you. That's the most important thing. But I hope it assists you in order to follow us. So paragraph 8 of the 10 July 2024 confirmed indictment reads as follows, and then I will continue with the other paragraphs. On the 5th of April 2023, Shala called Januzi. Bahtijari then also called Januzi. Then we go to paragraph 9. Then, after calling and verifying that witness 1 was at home, Bahtijari came to witness 1's home. Bahtijari told witness 1 that Shala had recently approached him and sent him to tell witness 1 that he should withdraw his testimony. Then we go to paragraph 11. Bahtijari left witness 1's home and walked to a nearby car where 2 men were waiting, with a 3rd person in the driver's seat. And then we go to paragraphs 14 till 18. Still with me, Mr. Shala? Okay, I see you nodding. We note that. In the days, we are now at paragraph 14, in the days that followed, Shala and Januzi, amongst others, remained in contact, including connecting by phone at least 4 times between April and 9 April 2023. On 12 April 2023, shortly after calling Shala, this is paragraph 15, Januzi went to witness 1's home. At witness 1's home, Januzi told witness 1 that Shala had asked Januzi to follow up on Bahtijari's visit and to find out what witness 1 planned to do and how the matter of his testimony could be addressed. Then we go to paragraph 16. Specifically, Januzi told witness 1 that Shala had asked Januzi to convey the message that if witness 1 withdrew his testimony, then Shala and unnamed others would provide him with help. Witness 1 responded that if Shala and or the others brought him 200,000 euros, they would have a deal. Witness 1 did not confirm or deny being a witness. Januzi said he would tell them what witness 1 had said. Then we go to paragraph 18. What I just read out was paragraph 17. Shortly after his 12 April 2023 visit to witness 1, Januzi again called Shala. And then we go to paragraph 24, little I under I, that reads as follows. On 5th of April 2023, at Shala's direction, Bahtijari approached witness 1 and told witness 1 that witness 1 should withdraw his testimony in KSC proceedings. Then we go to paragraph 24, double little I. On 12 April 2023, at Shala's direction, Januzi approached witness 1 to follow up after Bahtijari's earlier approach and to relay the offer that H.Shala and unnamed others would help witness 1 if he agreed to withdraw his testimony. And then the last paragraph I will be reading out, and you, according to paragraph 5 of the plea agreement, you agreed on. Paragraph 24, 3 little i's. Before and after approaching witness 1, Januzi and Bahtijari communicated and coordinated with each other and H.Shala. This was the content of the paragraphs in the confirmed indictment of the 10th July of 2024, as mentioned in paragraph 5 of your plea agreement with the SPO. Okay. I will now turn to paragraph 5 of the plea agreement, which states as follows, Mr. H.Shala. H.Shala and the prosecution, that's what you say in paragraph 5 of your plea agreement, no, we have to wait to be sure that Mr. H.Shala has the right paragraph in front of him. Paragraph 5, filing 618. Do you have that in front of you? Yes? Okay, I will read it out to you, Mr. H.Shala, and then I will ask you a question. H.Shala and the prosecution agree that if the prosecution were to proceed with evidence, the facts and allegations as set out in the paragraphs, and I have just read them out to you, 8 and 9, 11, 14 till 18, and 24 paragraphs, little I under I, double little I, and 3 double I of the indictment dated the 10th of July 2024, would be proven beyond reasonable doubt, and that those facts are true and correct and not disputed by H.Shala. Mr. H.Shala, do you confirm your agreement with this statement that I just read out to you?
Πού?
Yes.
We note that. Thank you, Madame Court Clerk, for your assistance. If I may ask you to remain some more there in order to assist Mr. H.Shala if needed. I will now discuss with you, Mr. H.Shala, the nature of the charges. Mr. H.Shala, the panel also wants to ensure that you are fully aware of the charges contained in the plea agreement. And for that purpose, I will read out to you paragraphs 3, 8, and 9 of the plea agreement itself. We are now in filing 618, paragraph 3. Do you have that in front of you?
Paul.
Very well.
Yes, I do.
Reads as follows. H.Shala agrees to admit guilt before the trial panel pursuant to Rule 94 of the rules in relation to counts 2 and 3 of the indictment dated 10 July 2024. To the extent they are alleging in count 2 obstructing official persons in performing official duties by participating in the common action of a group between at least 5 and 12 April 2023, punishable under the Kosovo Criminal Code, KCC, Articles 17, 21, 28, 33, 35, and 401, paragraph 2 and 5. And Articles 15, paragraph 2 and 16, paragraph 3, of the law on the Specialist Chambers and Specialist Prosecutor's Office, further referred to as law, and in count 3, intimidation during criminal proceedings by means of a promise of a gift or any other form of benefit between at least the 5th and the 12th of April 2023, punishable under KCC Articles 17, 21, 31, 33, 35, and 387, and Articles 15, paragraph 2, and 16, paragraph 3 of the law, including all modalities of liability alleged therein. I will now continue with paragraph 8, Mr. Shala. It's a lot of reading and listening, but I must assure ourselves that you have taken due notice of them. Paragraph 8 reads as follows. H.Shala fully understands that he is admitting guilt in relation to counts 2 and 3 of the indictment dated 10 July 2024, and specifically admitting his conduct as set forth in paragraphs 8 and 9, 11, 14 till 18, and 24, subparagraphs little I, under I, double little I, and 3 double I of the indictment, and as further described in the agreed factual basis. And then paragraph 9, H.Shala understands that if a trial were held, the prosecution would be required to prove the following elements of Articles 21, 387, and 401, paragraph 2 and 5, beyond reasonable doubt. And I will now listen the different elements of the counts. Count 2, between brackets, participation in a group which by common action, and reference to the Kosovo Criminal Court Article 401, paragraph 2, obstructs or attempts to obstruct an official person in performing official duties, and there's a reference to the same article. The offense was committed against a judge, a prosecutor, an official of a court, prosecution officer, or a person authorized by the court and prosecution often, or a police officer during the exercise of their official functions, a reference to Article 401, paragraph 5. And lastly, for this count, awareness of and desire to commit the act, or awareness that a prohibited consequence can occur as a result of the act or omission and accession to its occurrence, with a reference to Article 21. And then we go to count 3, and then I will list again the elements that the prosecution would be required to prove beyond reasonable doubt. First, under A, the use of force or serious threat or any other means of compulsion, a promise of a gift or any other form of benefit, with a reference to the KCC Article 387. To induce another person to refrain from making a statement or to make a false statement, or to otherwise fail to state true information to the police, a prosecutor or a judge, and such information relates to obstruction of criminal proceedings. This is the KCC Article 387. And lastly, awareness of and desire to commit the act, or awareness that a prohibited consequence can occur as a result of the act or omission and accession to its occurrence, with a reference to the KCC Article 21. Mr. Shala, after that I have read out these 3 paragraphs, can you confirm that you agree to the above charges?
Paul. Yes.
Thank you. Now, as regards admission of guilt, I will read out paragraphs 3 and 7 of the plea agreement. Paragraph 3 was also read out before in the context of the nature of the charges. However, it's also relevant in this context. So, Mr. Shala, I will read out to you again paragraph 3, but it is necessary in the framework of the question I want to ask you. Mr. Shala agrees, H.Shala agrees, this is paragraph 3, agrees to admit guilt before the trial panel pursuant to Rule 94 of the rules in relation to counts 2 and 3 of the indictment dated 10 July 2024, to the extent they are alleging in count 2 obstructing official persons in performing official duties by participating in the common action of a group between at least 5 and 12 April 2023, punishable under the Civil Criminal Code, KCC, Articles 17, 21, 28, 33, 35, and 401, paragraph 2 and 5, and Articles 15, paragraph 2, and 16, paragraph 3 of the law on the Specialist Chambers and Specialist Prosecutor's Office, the law. And in count 3, you agree to admit guilt to intimidation during criminal proceedings by means of a promise of a gift or any other form of benefit between at least 5 and 12 April 2023, punishable under the KCC, Articles 17, 21, 31, 33, 35, and 387, and Articles 15, paragraph 2, and 16, paragraph 3 of the law, including all modes of liability alleged therein. Mr. Shala, do you agree, do you confirm your agreement on this point?
Yes.
Thank you. And then paragraph 7. Do you have that in front of you? Yes? Okay.
Yes.
Yes.
Very well. H.Shala agrees to make an admission of guilt in relation to the charges identified at paragraph 3 above because he is in fact guilty and acknowledges guilt and accepts full responsibility for his conduct as described in the agreed factual basis. Mr. Shala, do you confirm your agreement on this point?
Yes.
Thank you. We will formally ask you to enter a plea later on in this hearing. Now, discussing still with you the terms of your plea agreement, we go to the sentence. Mr. Shala, I read in paragraph 11 of the plea agreement that you agree on the imposition of a sentence of 3 years imprisonment. And the plea agreement also states that in exchange for your admission, the SPO will recommend to the trial panel a sentence of 3 years imprisonment and recommend that Mr. Shala be given credit for the time served in the custody of the KSC. And as per paragraph 16C of the plea agreement, the SPO also agrees to withdraw count 1 against Mr. Shala. Do you confirm that, Mr. Shala?
Oh, yes.
Let me now turn to paragraph 12 of the plea agreement, which concerns legal remedies. As a preliminary remark, I recall that the SPO has withdrawn its request for reconsideration and/or leave to appeal of decision 612, which is filing 631, dated 16 December 2024. And as a result, paragraph 12 of the plea agreement is to be amended in order to conform to decision 612. And the panel will issue the necessary order in due course. I wish, however, to ensure that you understand how this impacts your plea agreement and that you agree with this change. And you may, of course, confer with your lawyer before you give your answer. I will first read out defense counsel, and then I will give you time to confer, and then we wait for the answer of Mr. Shala. Mr. Shala, do you understand and agree that should the panel approve the plea agreement and set a sentence which accords with the terms of the plea agreement, you will be precluded from pursuing appellate remedies against said decision? May I finalize? Thank you. You will not move, that is the second point, to withdraw your guilty plea or appeal your conviction pursuant to your guilty plea. And I would like you to confirm that you understand and agree to both of the above points, Mr. Shala, and you may, of course, confer with your counsel before you give your answer. Mr. Ketman, if you would like to confer with your client, I give you the opportunity.
Thank you, Your Honour. Mr. Shala is happy to answer your question now.
Thank you, Defence Counsel. Mr. Shala, I would like you to confirm that you understand and agree to both of the above points I read out to you. You have the floor.
Yes, Your Honor, I understood them, and I confirm and agree with the agreement reached between my lawyer and the prosecution office. If the sentence is 2 years, I will abide by it. If it's 3 years, I will not.
As read out in paragraph 11, I will only read out what is written there, agrees to the...
Marrëveshja, siç e lexova paragrafin 11, është shënuar këtu.
Another channel, because we have switched to another language, not to English now. I will repeat, Defence Counsel, the agreement, in the plea agreement, is that Mr. H.Shala agrees to the imposition of a sentence of 3 years imprisonment. If there is a misunderstanding on this, please confer with your client, because now I heard something about 2 years.
Your Honour, perhaps I can explain. What Mr. Shala was trying to confirm is if there is a sentence up to 3 years, of course, it's agreed a sentence of 3 years. He wasn't suggesting that there's any change to the plea agreement, but of course, any sentence that is up to 3 years, he would not be entitled to appeal that decision. So it's not a misunderstanding that the plea agreement has changed. It's if he's sentenced to 2 years, 2.5 years, or 3 years, he would lose his right to appeal that decision.
Very well. Is that sufficiently clarified from the side of for the Special Prosecutor's Office?
Yes, Your Honor.
Very well. Then we may proceed. On the SPO side, I note paragraph 16 of the plea agreement. Thank you, Madam Court Clerk. The same preliminary remark I just read out with regard to the withdrawal of your request for reconsideration and leave to appeal applies to paragraph 16b under A, where still reference is made to that possible appeal or reconsideration. Very well. Then we proceed to the following point, Mr. Shala. Under Rule 94, paragraph 5 under C, the panel must be satisfied that you entered the plea agreement from your own free will, Mr. Shala. And I note that in paragraph 24 of the plea agreement, you state that, and you can just listen to me, you don't have to, and if you want to look at it, I can give you the reference. It's paragraph 24, it's page 21. You have it in front of you, Mr. Shala? Very well, I see you nodding.
Po.
You state that no one has threatened or forced me in any way to enter into this agreement. And you state, I entered into this plea agreement freely and voluntarily. Your counsel also submits in paragraph 19 that you entered into this plea agreement freely and voluntarily. No threats were made, and that the only promise made to you are those set forth in this agreement. Mr. Shala, could you confirm before the panel that you have agreed to this plea agreement voluntarily, without threats or coercion?
Pozor justo.
Yes, Your Honor, everything has been done out of my free will. I've done everything voluntarily.
And you also understood what I just read out to you.
Po.
Yes.
Let us now move to the next point. The panel wants to confirm that you, Mr. Shala, understand the consequences of the plea agreement, if that is the case, of course, and that you waive your right to be tried under the ordinary trial procedure as per Rule 94, paragraph 5, under D of the rules, by signing this plea agreement. And on this point, Mr. Shala, there are several points I will walk you through. Yeah? First, I would like to read out paragraph 17, A till F, and paragraph 18, A and B of the plea agreement. And I give you some time to look for those two paragraphs in filing 618. Do you have them in front of you?
Po.
Yes.
These paragraphs summarize the rights you waive, you relinquish, and the rights you will still retain pursuant to the terms of the plea agreement. And I will read out to you first, Mr. Shala, which right you will be giving up by virtue of this plea agreement, in whole or in part. And those are the following rights. You are giving up, in whole or in part, the opportunity to exercise the following rights. Paragraph 17, under A. You will be giving up the right to plead not guilty and to require the prosecution to prove the charges in the indictment beyond reasonable doubt at a fair and impartial public trial. The right to be tried in your presence and to defend yourself through a specialist counsel at such trial. The right to raise defenses and grounds for excluding criminal responsibility and to present admissible evidence at such trial without prejudice to the right to make submissions and present evidence with regard to sentencing. The right not to be compelled to testify against yourself or to confess guilt. And the right to examine or to have examined the witnesses against you and to obtain the attendance and examination of witnesses on your behalf under the same conditions as witnesses against you, without prejudice to your right to examine any witness that may be called to testify, and your right to call witnesses and have them examined on your behalf at any proceedings with regard to sentencing, and the right to pursue appellate remedies with regard to conviction or sentencing as specified in paragraph 12 of the plea agreement, which I just read out. Mr. Shala, can I have your confirmation that you understand this and that you waive these rights?
Po, kam ku.
Yes, I've understood this paragraph.
Enough for me. I'm happy that it's important that you understand it, but it's also important that you waive these rights, that you know that you will not be entitled to these rights.
Yes, I waive these rights with the condition that the plea agreement is fully respected.
I don't know what that would mean. I read this right out, and I would like to hear from your client that he waives his rights in this respect. And I don't know what this condition would then mean.
Perhaps I could just take 2 minutes or 1 minute.
Good.
Your Honour, Mr. Shala understands. You can put your question again, and he will be able to respond.
Okay. And also to clarify, this is all subject to the plea agreement being approved. So that will be the status of these rights. Again, Mr. Shala, can I have your confirmation that you understand this and that you waive these rights?
Yes, I understand this and I waive those rights.
Thank you, Mr. Shala. Second, pursuant to the terms of the plea agreement, Mr. Shala, which are paragraphs 18A and B, is it understood that you retain all other rights, including in particular the right to be represented by specialist counsel at all stages of the proceedings and to communicate freely with such counsel in confidence, and the right to submit any information or evidence relevant for the determination of the sentence pursuant to Rule 162, paragraph 1 and 5 of the rules. You understand that you will still have these rights?
Yes, I understand that.
Thank you. Yes. Before I turn to ask Mr. Shala if he understands the consequences of the plea agreement and waiving his right to be tried under the ordinary procedure, I would like to give an opportunity to the SPO and to Defense Counsel to make any other observations or submissions they deem relevant, including as regards Rule 94, paragraph 5, E and F of the rules, if they deem it relevant. And yes, I will first give the floor to the Specialist Prosecutor's Office and then to the defense. Who can I give the floor of the prosecution team? Madam Prosecutor.
With regard to the provisions under Rule 94, subpart 5, and the colloquy that went towards subparts A through D, the SPO is satisfied that Mr. Shala has confirmed his understanding of the relevant provisions contained in the plea agreement, and overall his understanding of the same agreement and his voluntary entry into that agreement. The SPO would just observe, as is also provided in the plea agreement, that as to any additional submissions, the plea agreement is a complete document in that any and all terms agreed to between the parties are contained within it. And so no other provisions can be otherwise imported into the understanding between the parties besides what is written in the agreement itself.
Thank you. And no further submissions with regard to the requirement if there is sufficient factual basis establishing the essential facts that are required to prove the crime and the participation of the accused and the interests of justice that they are duly taken into account.
No, Your Honor. Given the paragraphs that have been read into the record and the fact that Annex 1, the factual basis itself, has been read into the record, our understanding and position is that those requirements have been met.
Thank you. Now I turn to defense counsel, and after that we will discuss the entering into a revised plea. Defense counsel, you have the floor.
Your Honour, as your question was limited to subparagraphs E and F, I'll restrict my comments to that. Nothing further needs to be added in terms of the factual basis and the test of interest of justice. We're satisfied with what has been read into the record. Mr. Shala accepts that and has made it quite clear that he accepts that. So I don't believe any further submissions would be necessary at this stage in relation to those specific points.
Thank you, defense counsel. Then we proceed. Mr. Shala, having heard the submissions of the specialist prosecutions office and counsel, may I ask you to confirm again that you understand the terms and consequences of this plea agreement and that you do not wish to change anything in the plea agreement that you have signed?
Yes, Your Honor. I am aware of the plea agreement. I understand it very well. It is in Albanian language as well. I've communicated with my counsel and I fully agree with it. I also understand its consequences.
Wish to change anything of the plea agreement?
The lower the sentence, the better.
Agree with what we have discussed. Now, I'm not laughing with you. It's a very serious matter. I want to have a clear answer.
Yes.
Do you want, in a legal way,
Yes.
Our dreams are something different, but in a legal way, is there anything you want to change with regard to this plea agreement you have entered into with the Specialist Prosecution Office?
Your underworld.
No, Your Honor. Everything is fine as far as I'm concerned.
Then, Mr. Shala, I will ask you to enter your plea, and to this end, I kindly ask you to stand, like we did also in pre-trial. Could you please stand? Mr. Shala, during the status conference of the 15th of December 2023, you pleaded not guilty to the charges of obstructing official persons in performing official duties by participating in the common action of a group under count 2 of the confirmed indictment of 6 December 2023 and the charge of intimidation during criminal proceedings under count 3 of the confirmed indictment of the 6th of December. And this is filing bearing number case 11, filing 7, Annex 1. Are you ready to change your initial plea of not guilty? Defense counsel, yes, please.
Nerd Koku kam declare.
At the time when I pleaded not guilty, I had never been interviewed by the SPO and was not fully informed what was it all about. Now I plead guilty to what I have agreed in the plea agreement.
Counsel, I take this as yes, I want to change my plea.
In accordance with the terms of the plea agreement, yes,
Yes.
Your Honour.
Okay, thank you. Mr. Shala, I will proceed because now I will read out to you, and please remain standing. I will read out to you, and I will ask you if you plead guilty to what I read out to you. Yeah? So, I will proceed to read out counts 2 and 3 as reflected in the confirmed indictment of the 10th of July 2024, and ask you to enter a plea for each one of them. So count 2, obstructing official persons in performing official duties by participating in the common action of a group between at least 5 and 12 April 2023, a criminal offense against public order punishable under Articles 17, 21, 28, 33, 35, and Article 401, Paragraph 2 and 5 of the Criminal Code of the Republic of Kosovo of 2019, and Articles 15, Paragraph 2 and 16, Paragraph 3 of the law. Mr. Shala, how do you plead? Guilty or not guilty?
Victor.
Guilty.
Then I proceed to count 3, intimidation during criminal proceedings between at least the 5th and the 12th April 2023, a criminal offense against the administration of justice and public administration, punishable under Articles 17, 21, 31, 33, 35, and 387 of the Criminal Code of the Republic of Kosovo of 2019, and Articles 15, Paragraph 2 and 16, Paragraph 3 of the law. Mr. Shala, how do you plead? Guilty or not guilty?
Guilty.
Thank you. We will now turn to the defense. You may be seated. We will now turn to the defense submissions on sentencing. Mr. Shala, here I will have some questions which I will address to your counsel. You may, of course, confer with him, and please do let us know if there's anything that is unclear or difficult to follow. I see you standing, Defense Counsel.
As you were addressing me, Your Honour, that's why.
Okay, I wanted still to formulate the questions, but thank you for that. Defense Counsel, the SPO submitted yesterday the criminal records of Mr. Shala, which is filing 629, Annex 1. Do you wish to respond to the specialist prosecutor and to the panel on this? And if you would like to discuss it, should we then go into private session or not?
Your Honour, I have raised this with Mr. Shala this morning. Obviously, these matters were disclosed to us yesterday, outside of the direction that Your Honours had given for any material that should be put before the court for the purpose of the sentencing. So it falls outside of the deadline for which you had directed. The other matter, there are 2 matters that, as Your Honours will see, involve suspended sentences. Now,
Do you want us to go into private session?
I'm not going to go
only?
into any detail
Okay.
as to the nature of those matters, but certainly it is my submission that those are matters that the prosecution relies upon as an aggravating factor. Certainly it is our submission that these are not matters for which Your Honours have any jurisdiction to deal with, other than considering them as aggravating factors, as has been submitted by the prosecution. Whatever consequences may follow as a result of those, that is a matter for the courts in Kosovo, not for the specialist chambers to deal with.
Noted, Defence Counsel. Specialist Prosecutor, do you want to reply to Counsel for Mr. Shala?
Your Honor, just to note that the referenced convictions are submitted for aggravating factors in terms of sentencing, limited to these proceedings. As Defense Counsel has noted, what might happen later is something else. Those are for these proceedings.
Thank you. Yes, no, I was just reading, I took off the microphone just to understand better what you just said. Thank you. Noted. So no further issues on this other than raised just now, and the panel has noted that. Then there is another point. Yes. It's not sentencing, but another subject. It's reparations. The panel notes that it's the view of the defense that reparations are inapplicable in this case because the agreed factual basis does not imply that any natural person personally suffered harm as a direct result of the crimes in relation to which the accused has agreed to admit guilt. Yes, I see you nodding. This was in your sentencing submissions, paragraph 37, if I recall well. Defense Counsel, do you wish to make any further submissions on this matter?
Your Honour, there were 2 points that were set out in respect of reparations, and obviously Your Honour has raised that question this morning, giving a deadline until the 20th of January. First of all, no prior notification, no application has been made in respect of any reparations by the Specialist Prosecutor's Office. And second of all, on the basis of the plea agreement, the limited basis in respect of count 3 demonstrates that there was no harm suffered, as we've set out in our sentencing note. On that basis, we say there is no proper basis for the court to proceed with any consideration of reparations in this particular case. That is also a matter that this court had taken in its previous obstruction matter, the case of Gutsati and Haradinaj, where no reparations were ordered on the basis that there was no evidence before the court, no admissible evidence before the court, as to any harm suffered by any natural person. So my submission is that there is no proper basis for the court to proceed on the question of reparations. It is merely a matter of accepting or not the terms of the plea agreement and the sentence that has been agreed upon between the parties.
Thank you, Defense Counsel. Position is clear. Yes, then I turn to the Specialist Prosecutor's Office. To whom can I give the floor?
To me, Your Honor.
Very well, you have the floor, Mr. Prosecutor.
Your Honor, we noted as an initial matter that there was, obviously, as a plea is being entered, there was no trial in this case. And as Your Honor announced, and the panel announced earlier this morning, there will be a procedure for victims to participate in this case. which will provide the relevant basis for any reparations that may be ordered. We also note and dispute the position of the defense regarding harm to the victims, any victims in this case. And we note the plea agreements did not in any way limit the parties' ability to offer admissible evidence or make relevant submissions, so long as the evidence and submissions are not inconsistent with the plea agreement and the agreed factual basis, which harm to natural victims is not inconsistent and, in fact, a logical result of the actions in this case. And should your honors desire to hear more of that, at this moment, the SBO is prepared to offer that, perhaps in private session, in the form of the statements of the victims.
Thank you, Mr. Prosecutor, but would you be prepared to, you mean now, because that's not clear for me. You say in private session at this moment in time or at a future moment?
Oh. Yes. Your Honor, the evidence I was referring to before from the victims was evidence that had been given through disclosures. We would make any relevant submissions in the future in the appropriate context, but do not feel they're necessary at this time.
Thank you. That clarified already my question I was having. Defense Counsel, I agreed with you that I would give you the floor. My question has been clarified. Maybe there's something you would share with them.
Well, I do wish to comment further on that.
Thank you.
First of all, no evidence is before the court. No evidence has been offered. And if you look at paragraph 15 that deals with reparations, it says that the SPO and the defendant, and then it goes on to discuss at or prior to the time of sentencing. It is our position that the SPO has had ample opportunity to address this matter. It has failed to do so. It should not be given additional time. And it wasn't until Your Honours raising it this morning that we now hear that there is evidence that is going to be proposed, but there is no evidence, admissible evidence before Your Honours that would enable you to address the question of reparations as the SPO is now seeking. And so it is my submission, I'm inviting the court to dismiss that in its entirety, that there should be no order as to reparations, because you have no evidence before you, and we are unaware of what evidence is to be put before the court at some future stage.
Thank you, Defense Counsel. I will allow, if necessary, for an extra round, if that is necessary, but if all views are sufficiently exchanged, then we leave it here.
No extra round is necessary, Your Honor.
Thank you. Thank you. Yes, then we will proceed with one point more, and that is for Mr. Shala. Mr. Shala, I turn to you. I note that your counsel indicated in his email of yesterday, 8:50 in the morning, and for the correspondence number, it's 106, that it is not anticipated that you will make any statements at today's hearings. I noted that. I have some questions for you in this. I have some questions for you, but you are, of course, under no obligation to answer that. Yeah? I would like to know, the panel would like to know, if you, Mr. Shala, would like to express any remorse in the sense that you feel sorry for doing something wrong regarding the agreed factual basis. No, you may remain seated. But I see that your defense counsel is standing.
This is a matter, obviously, that was not anticipated. I would like a moment to consult with Mr. Shala on that. But that's not really a matter that I can deal with in the back of the courtroom in 1 minute. I don't know what time Your Honours were seeking to rise for the lunchtime break, but of course that is a matter that I would like to consider with Mr. Shala, because he has given a clear indication that he is not making any statement today. I understand that he's not obliged to answer that question, but if there are to be more questions along those lines, I would be grateful if Your Honour puts those questions to Mr. Shala now, so that I can then have time to consult with him as to whether it would be appropriate for him to respond to those questions.
Defense counsel, you will be allocated some time if you feel the need for that. That's to start with. For the panel, one thing is between a statement. You can have a statement on, and your point is clear that he would not be doing that. That doesn't take away the possibility from this panel to, because it could be a factor in sentencing, to take on board, and that's the background of our question. And if it would come so far. So, how much time would you need?
Well, I can certainly have a very brief discussion with him now, and then I can come back to you if I'm going to need additional time. But if you permit me to just speak to Mr. Shala now.
Yes, because I will tell you, this is the last part of this plea hearing, unless parties would like to raise something else in this regard, regarding the plea agreements between Mr. Shala and the SPO. So, yes, I would like to know how much time you would need, because I have a preference to finalize this part of our hearing before we go for lunch. So, if you could confer with him to see what and how, and then you come back to me and we take it from there.
And certainly it is anticipated that I would be making submissions on his behalf. Obviously, I can't answer for the SBO as to what their position is, but certainly I would be making submissions on the question of sentencing. I don't believe I would require any more than 10, 15 minutes, but it's certainly there are matters that I was expecting to raise.
Okay, but if you want to make submissions on sentencing, very well, I will give you the floor for sentencing, but could you first confer with your client, and then I will give you the floor on sentencing. Good? Defense counsel, you're standing. I give you the floor to share with us what the results of your...
Obviously, only having had a brief moment to
Yes.
discuss that with Mr. Shala, he is content with me making submissions on his behalf.
So I deduct from that that he is not going to say anything on remorse.
As I said, he is content for me to make the submissions on his behalf. He's not in a position to answer your question.
Then I note for the record that on my question if there's remorse, he didn't want to give an answer. That's what he doesn't want to reply to me on that.
That's correct, Your Honor.
Okay. That's noted for the record. Thank you. Defense counsel, you wanted to make submissions, and of course you must have that opportunity on sentencing. So what we will do is I give you the floor, then I will give the floor to the Specialist Prosecutor's Office, and we will have an extra round for any replies on arguments raised by both parties, and then we will adjourn to go for lunch. Yes? Good. Defense counsel, you have the floor.
Thank you, Your Honor. Your Honor will, or Your Honours, will have received the sentencing submissions that have been provided on behalf of Mr. Shala, which is at 616, dated the 6th of December. And of course, we've gone through in some detail the plea agreement and the extent to which Mr. Shala has admitted guilt in respect of that plea agreement. Your Honour, first of all, dealing with the obstructing official persons in performing official duties, as we've heard, that falls under Article 401, paragraph 2. And then the matter of intimidation during criminal proceedings under Article 387, noted that that is limited to the offer of a gift and not through any other form of intimidation. It is limited specifically to the offering of a gift. I would submit that the conduct for which Mr. Shala has entered his plea falls relatively low down the scale of severity in each case. With regards to count 2, firstly, the agreed basis of the plea agreement does not state that that Mr. Shala actually obstructed official persons in performing their duties. Rather, it implies that there was an attempt to do so. That will be found in paragraph 10 of the sentencing submissions on Mr. Shala's behalf. Secondly, the conduct is relatively small scale in that it consisted of an approach to one individual on 2 separate occasions. Although it is accepted that Mr. Shala communicated with Mr. Bahtijari and Mr. Januzi, as is set out in the plea agreement, such actions would be inherent in a crime that requires participation in a group of persons, which obstructs or attempts to obstruct by common action. That's dealt with at paragraph 11 of our written submissions. Thirdly, there was no abuse of power or official capacity by the accused. And finally, as we have heard this morning, there is no implication that any tangible harm resulted from the accused's actions. That's at paragraph 12 of the written submissions. For those reasons, we would say that count 2 is at the lower end of the scale of gravity, and therefore the sentence that has been agreed with the prosecution is entirely in line with that. With regards to count 3, again reminding ourselves that it is solely intimidation through the promise of a benefit or a gift, and not by the use of any serious use of force or serious threat or any other means of compulsion. And that's paragraph 14 of our written submissions. Looking towards the practice of this court, the trial panel in the Guzzati and Haradinaj case, the only other case that has been determined by this court, for obstructing official persons in performing their official duties by participating in a common action or group, both accused in that matter were sentenced to 1 year of imprisonment. That's it. Trial judgment in that matter, paragraphs 981 and 1006. For the intimidation charge, a sentence of 4 years was given to both accused in that matter, and an overall sentence of 4.5 years that was later reduced to 4 years, 3 months on appeal. There are a number of key aspects of the Guzzati and Haradinaj case where it is clear that the matters for which they were convicted were more serious and had a higher level of gravity than those that are the subject to the plea agreement in this matter. Again, looking at these matters in the round, it is clear that an agreed sentence of 3 years is entirely consistent with that approach. In the Guzzati and Haradinaj case, it was found by the trial panel that the acts and statements of the accused amounted to a serious threat. It was also found that there were fears and concerns for those persons who were the subject of that serious threat. The gravity of the crime under Article 387, to which Mr. Shala has agreed to plead guilty, does not involve the use of a serious threat, but only the promise of a gift or another form of benefit. Further, I would invite your honours to consider that the sentence in Guzzati and Haradinaj was of a higher level because they were convicted of other matters, not just that single charge. And thirdly, it is quite clear, as the record shows, that neither of the accused in Guzzati and Haradinaj pleaded guilty or entered a plea agreement, which must inevitably lower the sentence that your honours ultimately impose. It's also clear that a sentence of 3 years for the conduct for which Mr. Shala has agreed to is entirely consistent with the practice of other international courts and tribunals. In our written submissions, we refer to the case of Harachia and Marina.
Yeah, Defense Counsel, it's not necessary to repeat all the cases you have listed, because I can assure you that we have been going through them really carefully, because they're of course very relevant. So rest assured that we have seen, and I see that you want to make your point, and I want to give you the floor for that. Certainly. At the same time, we don't have to repeat the whole submissions in that respect.
And Your Honour, rest assured, I have no intention to repeat what's in the sentencing note, and I have no intention to go in detail to the cases that have been mentioned, only for the purpose, as this is a public hearing, to ensure that these points are put on the record. There are 3 matters that are referred to in the sentencing note. As I mentioned, Harachia Marina, Milan Vuyin, and Bechai, which is an ICTY case. Then we mention a case before the International Residual Mechanism. And then, of course, we focus on the case of Bemba at the International Criminal Court. All of these cases concern offences against the administration of justice. And in each case, and I would submit that the conduct in each of those cases is on a higher level of gravity than this case, a higher level of gravity as to what the terms of the plea agreement set out. And of course, it is accepted that in any case such as this, it is determined on the facts specific to each individual case. But of course, by looking at those cases, you can see that a sentence of 3 years for the conduct which has been admitted to is not inconsistent. In fact, it is higher than the sentence in all of those cases. So I would submit that the overwhelming weight of the existing case law before other courts and tribunals supports the sentence that has been agreed with the prosecution. Dealing with the prosecution's submissions on sentencing, first of all, Mr. Shala has agreed to admit guilt in relation to counts 2 and 3, and he has agreed to the imposition of a sentence of 3 years. And in exchange for his admission of guilt, should it be accepted by your honours, the prosecution has agreed that it would recommend a sentence of 3 years that has been accepted by Mr. Shala, and that he should be given credit, as would be the case, for the time that he has already served whilst in the detention unit of this court. In spite of this agreement, the prosecution makes submissions in its urgent prosecution submissions on plea agreement and sentencing that would suggest that the conduct that Mr. Shala has agreed to, and which the prosecution has agreed to, is more serious than in fact it is. They don't take account for what we say is a low level of severity for the 2 offences for which he has admitted guilt. They make allegations to the detriment that have no basis in the plea agreement and is not supported by evidence. And they erroneously argue that no substantial weight should be given to any possible submissions of Mr. Shala's character or of any of the accused. Dealing with the first point, the prosecution alleges that in agreeing the sentences or sentencing range within each accused, the SPO took account of Rule 163, subparagraph 2, which required a reduced sentence in the event of a plea agreement. As such, in this case, there are no further circumstances which could mitigate the sentence to be imposed on the accused, which is what they say in paragraphs 24 and 31 of their written submissions. This ignores the respects to which the offences, which Mr. Shala has agreed to, that he has committed, will low down the scale of severity. In relation to count 2, Mr. Shala only attempted to obstruct official persons in performing their duties. The conduct was relatively small scale, as I've already mentioned. There's no abuse of power, no official capacity, and as we've heard, no tangible harm resulted from his actions. In count 3, he did not use force or serious threat or any other means of compulsion, and there is no evidence of tangible harm present, and the conduct is relatively small scale. But the prosecution repeatedly urges this trial panel to impose significant terms of imprisonment on the accused without acknowledging where these offences fit within the sentencing scale. In relation to the second point, it is important to stress that, as is in paragraph 1 of the plea agreement, this agreement sets out the entire understanding of the parties as to the nature and consequences of H.Shala's admission of guilt. I emphasize entire because what is set out in the plea agreement is the entirety of what is agreed between the parties. I would direct your honours to paragraph 14 of the plea agreement. I won't read it out now, but it is important for your honours to consider the implications of paragraph 14. I would submit that the urgent prosecution submissions on plea agreements and sentencing contain a number of factual allegations that do not amount to either admissible evidence or valid submissions. Looking at paragraph 17, during the explanation of count 1 as charging attempted obstruction, there is reference to the witness confirming what was exactly what had happened, that a serious threat had been made. That is not part of the plea agreement. That is not part of the terms of the plea agreement. There's reference to the presence of the family of witness 1. Again, not within the terms of the plea agreement. The implication that witness 1 and 4891 were protected witnesses, and a claim that both witnesses experienced significant fear for their safety and that of their family. Again, not part of the agreement, not part of the plea agreement, and I would invite your honours to disregard those submissions. It is clear that these factual statements advanced by the prosecution are not contained in the plea agreement and are not supported with any admissible evidence before your honours, and you should not consider them. In terms of the submissions that the character of Mr. Shala should be given substantial weight, despite the existence of the plea agreement, the prosecution states that there's been a lack of cooperation on the part of Mr. Shala. Not once has the prosecution raised that with Mr. Shala in terms of any cooperation. It further stated that none of the accused have made any efforts to compensate the victims. Again, as we've heard repeatedly today, there is no evidence to suggest that any of the individuals involved in this process to which Mr. Shala has entered a plea agreement has suffered any harm for which he would be required to compensate. And certainly, as I've already said, regardless of that, no request has been made until today that there should be any form of compensation. The prosecution infers from this the lack of cooperation and failure to compensate, that no substantial weight should be given to any possible submissions as to character, as to his character. That is at paragraph 69. This entirely misses the point. The prosecution's submissions have no bearing on the character references, and I won't go into the detail of the character references that are contained in the confidential annexes 1 to 4. But what I would say is that these references demonstrate that a long sentence of imprisonment would have an especially damaging effect on Mr. Shala and his family, and it would reduce the contribution that he could make, not only to his family, but to his community and to his country, which is set out very clearly in those character references. I would also ask your honours to consider that whilst Mr. Shala has been detained in relation to these matters, his father passed away, and he had very limited time with his family as a result of that death. It is important for your honours to take that into account. I don't intend to deal with the additional disclosure that was made just yesterday in relation to the evidence of prior convictions. Your honours have those. As I've stated, this is not a matter of which you would have any jurisdiction to deal with. That is a matter for another court to deal with. But I would ask you to look at those and identify them in their proper context as to the severity of those offences. Again, offences at the low end of the sentencing scale, which is reflected in the suspended sentences that were imposed. I will make note of the fact that the direction by your honours was for all of this material to be disclosed by the 6th of December, and it was disclosed 11 days later yesterday. In any event, that evidence has no relevance to the character references that have been provided on Mr. Shala's behalf. What those character references do show is the devastating effect that a long sentence would have on Mr. Shala and his family. The question of reparations has been dealt with, and I won't deal with that any further. I again invite your honours, on the basis of what I have already stated, that there is no proper basis upon which any order for reparations should be considered. I recognise the oral order that your honour made this morning that would further delay the finality of these matters. And it is important to recognise that finality is an important consideration in a matter such as this. Mr. Shala has already been in custody for over a year now. He is very keen to understand the outcome of these proceedings. So delaying matters further is going to cause further harm to Mr. Shala in that regard. Well, Your Honours, I have gone a little bit over time. For that, I do apologise. But I think it was important to put in the proper context what has been agreed, that what has been agreed is entirely consistent with this court's practice and the practice of other international courts and tribunals. The sentence that has been agreed upon with the prosecution is entirely appropriate. And I would invite Your Honours to accept that all of the conditions are met under the legal framework of this court for that plea agreement to be accepted, and for that sentence to be accepted. There is a proper factual and legal basis for doing so, and I would invite Your Honours to rule accordingly, unless I can assist any further.
Thank you, Defence Counsel. I now turn to the Specialist Prosecutor's Office, and first, in order to do some planning, Mr. Prosecutor, how much time do you think that you would need? We are approaching the 2 hours we had envisaged for this hearing, which doesn't mean that you will not be allowed the same amount of time as we allocated, or we have given to the defense. But I would like to see how we are going to proceed, based on what you share with me.
Yes, Your Honor, you have our written submissions. I will be responding to the defense. I don't anticipate taking longer or much longer than 10 minutes.
Okay. Then, in that case, I will give you the floor, and anyhow, if that would lead to Mr. Ketman to respond to what is being said, I will give that opportunity, and then you may respond too, and then I think there we could wrap it up and then go for lunch. That is how I intend to proceed. You have the floor, Mr. Prosecutor.
Thank you, Your Honor. I think the most important thing to highlight is what we agree with the defense on, which is that 3 years is the just and appropriate sentence in this case. And contrary to what's been asserted by the defense, this does fit within the scale of offenses of this nature. 10 years is the maximum sentence. The sentence is 3 years. That has been accounted in the SBO's reckoning. What we disagree with the defense and the accused is on the severity of the conduct in this case. Looking at the agreed factual basis and the relevant agreed sections of the indictment, one can only conclude that Mr. Shala was the beginning, the end, and everything in the middle that occurred during the criminal conduct in this case. Mr. Shala was the beginning because he directed the other accused in this case in their actions. He was the end because he was the supply of help or money that would come in this case. And contrary to the minimizing assertions of the defense that such communications are inherent in these offenses, Mr. Shala was the engine that drove these criminal acts with constant communication with multiple accused and multiple approaches, a second approach when the first approach did not work. So in this manner, his conduct is severe. The scope of the interference in this case was also substantial. There were multiple approaches to witness one by two of the accused at his home, at the direction of Mr. Shala, acting as part of or on behalf of unnamed others. The harm in this case is not just to the victims. The impact of these offenses as part of the continuing pervasive climate of witness interference cannot be overstated. Indeed, it is why we're here today, that protected witnesses at the Kosovo Specialist Chambers can be repeatedly approached and subject to criminal conduct has the potential chilling effect on the public confidence in the effectiveness on KSC orders and decisions, including those related to protective measures. Deterrence in the form of a significant sentence protects this confidence. In that regard, Mr. Shala, the defense for Shala has made comparisons to the Gusadi and Haradnai case and argued elements present in that case and not in this case render it more serious. On the flip side, elements present in this case and not present in that case render the conduct here more serious. Shala defense ignores that the victims in this case were approached in person, in their homes, on multiple occasions, by multiple accused, at the behest of Shala, a former KLA commander, and again working in coordination with unidentified others to stop witness one from testifying at all costs. This flies in the face of the argument that there is not even the implication of tangible harm. the defense has highlighted paragraph 14 of the plea agreement, which, as previously indicated, allows such evidence and submissions that are not inconsistent with the agreement and the agreed factual basis. Indeed, the defense has made such submissions in the form of harm to Shala and his family, yet seeks to exclude the SPO from making comparable submissions on harm to the victims in this case, which has been supported in disclosures in this case and is not just consistent with the agreed factual basis in this case, but the logical conclusion of such actions. The defense has referenced the weight that should be placed on character evidence in this case. And Mr. Shala has provided sentencing submissions from friends and family. The panel is free to give those submissions the weight it deems appropriate. However, the SPO asserts that the more appropriate and relevant metric of Mr. Shala's relationship with the rule of law and willingness to engage in the type of intimidation and obstructive conduct present in this case is his criminal history. This has been submitted to the panel. And, as such, Mr. Shala's prior criminal conduct serves as an aggravating factor justifying the sentence
multiple approaches, it is quite clear that there were two approaches. In terms of the exchange, any potential exchange of money, Your Honours will recognise that that was a matter that was advanced by the witness, not any of the accused. I don't want to labour the point as far as harm, but the prosecution has to recognise that it is bound by what it has agreed to in the plea agreement, in which there is no harm and there is no evidence of any harm. And then finally, in respect of the two convictions, again, Your Honours have those. You can read the details as to those convictions and put them in their proper context for what they are. The only final remark I would make is that the suggestion that a criminal matter falls at the bottom end of the sentencing scale does not minimise or trivialise an offence. It just puts that offence in its proper context. And so the submissions made puts these matters on the basis of the plea agreement in the proper context that it falls at the lower end of the sentencing scale, and therefore a sentence of 3 years is entirely appropriate. That is the point that was made. The only other remark that was made towards the end in terms of cooperation, that there was an invitation from the prosecution after Mr. Shala had been detained for a period of time whether he wanted to submit to a voluntary interview. And upon advice, he declined. He was not interviewed prior to his arrest. He was not interviewed immediately following his arrest, but several months later, where he had already been detained at the detention unit. There was no other invitation to cooperate during the currency of these proceedings, either prior to the inter-partes communications on a plea agreement or following those discussions. That was the point that was made. So to suggest that it is an aggravating factor that he hasn't cooperated, you cannot penalise him for something that he has not been given any opportunity to do. Thank you, Your Honours.
Thank you, Defence Counsel. Anything the SPO wants to raise in this regard?
Nothing further, Your Honour.
Thank you. So, Defence Counsel, the SPO has nothing more to raise, so you were the last one to talk in this respect. Oh, something you would like to add, Defence Counsel?
I've just been reminded of one point that I should have made.
Yes.
And it is not appropriate to penalise an accused in a matter such as this for wishing to speak through his advocate. It is entirely appropriate for submissions to be made through his advocate. And that was the only, I think that was the final point that the SPO made in terms of expressing remorse. He has elected to speak through his advocate, which is entirely appropriate, and he should not be penalised for that.
Thank you, Counsel. This is noted. If there is, then my final question would be, at this moment in time, is there anything that the parties would like to raise with the panel before I conclude for this moment this hearing on the plea agreement for Mr. Shala and TSPO? Yes, Defence Counsel.
The question was asked whether Mr. Shala would want to attend tomorrow's hearing. He has elected not to. I understand that a written waiver is required, but obviously it is quite difficult for us to, other than a handwritten waiver that we will endeavour to provide the court with. But certainly he has elected not to attend tomorrow in person or video link.
Thank you for that. But for the formal requirements, I'm sure that CMU will be able to assist you in a very proactive and helpful way. So if you liaise with them, I'm sure that that will be resolved. However, the presence for the hearing after the hearing regarding the plea agreement between Mr. Bahtijari and the SPO, there will be an additional hearing after the half an hour's break when we finalize that hearing to wrap up everything. And if something will come up, the presence, so for that hearing, the presence of parties is required. So even if the accused don't want to participate and their presence is not required, for this wrap-up hearing, so to call, I would or request the presence of the lawyers. So very well. We are now at the end of the hearing on plea agreement entered between Mr. Shala and the SPO. We will now go for a break, and that will be a 1.5 hour break. So we will continue. We will start not at 2:30, but we will start at 3 o'clock. Mr. Rees and SPO, Mr. Prosecutor, and we intend to proceed till around 5. I think that less or more that's what happened now, a little bit more, but that is our plan for this afternoon. So I adjourn the hearing and see you back at 3 o'clock. Thank you.
All rise. All rise.
Please be seated. Welcome again for this afternoon session. We will first call the appearances. Let me see. I will ask the parties to introduce themselves, and I will start with the defense for Mr. Januzi. Defense counsel, you have the floor.
Thank you, Your Honour. Representation remains as per this morning.
Thank you very much. Specialist Prosecutor's Office, you have the floor.
Tasneem Shahabuddin, prosecutor for the Specialist Prosecutor's Office. We also have the same team present as this morning, but nevertheless, I have with me to my left, John Devaney, associate prosecutor, Joshua Hayfitz, prosecutor, and behind us from our case manager, Lena Peterson. Thank you.
Thank you very much. And from the other defense teams, defense for Mr. Shala, you have the floor.
No change from this morning's representation.
Thank you very much. And for Mr. Bahtijari.
A small change from this morning. There are just 3 of us here this afternoon. Myself, Felicity Gerry, co-counsel Marian Karin, and Yuching Leo. Thank you.
Thank you very much. We will now begin with the hearing regarding the plea agreement entered between Mr. Januzi and the SPO. And for the record, I note that a plea agreement was entered between Mr. Sabit Januzi and the Specialist Prosecutor's Office on the 6th of December 2024. And the accused specialist counsel is Jonathan Elliston Rees, counsel. Can you confirm this?
Yes, I can, Your Honour.
Thank you. Before we begin, we will proceed to confirm the signatures of both defense counsel and Mr. Januzi on the different versions of the plea agreement, both in English and in Albanian. And I would like to proceed to see if we can do it all via electronic way instead of sharing with Mr. Januzi the plea agreements. So I ask Madam Court Officer to pull up filing 618, Annex 1. We will confirm both in I see. Yes. It's Annex 2. Yes, for sure. Annex 2. In filing 618. And then we will go to Annex 1 of filing 632. Could you please go, Madam Court Officer, to page 9 and 10 of this document? And I will allow you, Madam Court Officer, to put on both the English and the Albanian version. Thank you. We have now page 10 in front of us, both of the Albanian. Okay, no. Sorry, no, I would like to have the Albanian version of. Oh yes, sorry, Madam Court Officer, I'm making some confusion here. Yes, thank you very much. Mr. Januzi, do you see on the screen in front of you the versions, the English and the Albanian version of the plea agreement you signed? Madam Court Clerk, could you please assist? Yes? And the signature in the Albanian version, is that your signature?
Microphone, please.
Could you repeat your answer?
Yes, it is my signature. Interpreter knows that the microphone is still not on.
Please, is the microphone on? Because could you, Mr. Januzi, can you please repeat your answer? Because your microphone was not on, and we need that to put your answer on record.
Yes, it is my signature.
In the Albanian version, that is your signature. Yes.
Po.
Yes.
Sides, there we have the English version of your plea agreement. On page 10, in the English version, is that your signature?
Yes, it is my signature.
Very well. Thank you for that. Madam Court Officer, could you bring us to filing, could you bring us to the page 11? Mr. Januzi, is in the Albanian version on the left-hand side, is that your signature? The second one counting from up.
Po.
Yes, it is.
And in the English version, on the right-hand side, the first signature from counting from above, is that your signature?
Po.
Yes, it is.
For that. Then we stay here, and I ask Defense Counsel for Mr. Januzi, in both versions, both the Albanian and the English one, on the left and the right-hand side. Is that your signature, Defense Counsel?
That is my signature
Both.
in both versions.
In both.
This is actually quite a useful exercise because having the two documents alongside each other does lead me to suggest that perhaps you should also ask for Miss Shahabuddin to confirm that those are her two signatures, both of which are in her name. One the 17th of December and the second the 6th of December.
I'm most happy to ask that.
I am able to confirm that it is both my signature that appears, as well as the specialist prosecutor's signature who signed in my presence.
We have noted that. Thank you, and thank you, Mr. Rees.
Natural variance.
Then we go back to page 10 in both versions. Yes, and then the Albanian version and is not of relevance in this case, but the English one is. Defense Counsel, can you confirm that in the English version we see your signature?
Not on the screen. Not on.
Are you sure?
Sorry, we do in the English version, indeed.
Yeah, I
Can't
said.
see my signature on the Albanian version.
No, but that's what I said. Only the English version. But very well, thank you for confirming that.
Thank you.
Good. Thank you, Counsel. Let me proceed. Mr. Januzi. Yes? No, it's not necessary to put on his microphone yet. Thank you. Mr. Januzi, every time you will, I will ask you a question and I will ask you to give an answer. Yeah? Please switch on the button of the microphone. Yeah? Do you understand how it works? Yes? Because we will not be having the court clerk the whole hearing standing next to you. So if I ask you to give an answer to a question, the idea is that you switch on the microphone, because if not, I cannot hear your, the translation of what you're saying. Huh? So it's really important. Good. Madam Court Clerk, I think that for now, thank you for your assistance. Now, Mr. Januzi, as you know, and certainly your counsel is aware, the panel may approve the plea agreement as concluded between the SPO and your counsel on your behalf, if it is satisfied that certain conditions are met. This is what Rule 94, paragraph 5 of the rules requires. Therefore, I will proceed to ask you some questions, and I will also ask the SPO and your counsel questions where necessary in order to verify whether all the conditions as set out in Rule 94, paragraph 5 are met. You understand that?
Po, të
Yes, I understand.
Very well. First, I will begin with Rule 94, paragraph 5 under A. In the plea agreement signed by you, it is indicated that you have discussed the terms of the plea agreement with your counsel and that you have entered the plea agreement after sufficient consultation with him. And I refer to paragraphs 6, 19, and 24 of the plea agreement. Mr. Januzi, can you confirm that this is the case?
Yes.
Thank you. Now I turn to Rule 94, paragraph 5, under B and C. In this context, I will go through the terms of the plea agreement in order to allow the panel to assess that you understand the terms of the plea agreement and that you agree to the terms of the plea agreement. So I want to know if you understood them, and I want to know if you agreed to them. Mr. Januzi, do you confirm that you have carefully reviewed with your counsel every part of the plea agreement in a language you understand, and that you understand the terms of the said agreement as specified in paragraph 24 of the plea agreement?
Po, konfirmoj.
Yes, I do confirm that.
You confirm that you understand it, and you confirm, yeah? You confirm that you understand that you took notice of it in a language you understand, and you understand the terms. So you understand what is said, and you understand the terms.
Po.
Yes.
Thank you. Now, we turn now to Rule 94, paragraph 5 under C, concerning the facts admitted by you, Mr. Januzi, underlying the charges contained in the plea agreement. And I will start with Annex 1 to your plea agreement, which is page 12 of Annex 2 of filing 618, which contains the agreed factual basis. And Madam Court Officer, if you could pull that up, both in Albanian and in English. Thank you very much. Mr. Januzi, I will read out the agreed factual basis. The defendant, Sabit Januzi, accepts that he was part of a group which sought to induce witness 1 to refrain from giving evidence before the Kosovo specialist chambers through the promise of a benefit. In particular, members of the group, acting at the direction of H.Shala, approached witness 1 at his home on 5 and 12 April 2023, respectively. During the 5 April approach, Ismet Bahtijari told witness 1 that he should withdraw his testimony before the Kosovo specialist chambers. During the 12 April 2023 approach, the defendant, Sabit Januzi, followed up on the first approach and relayed to witness 1 an offer that H.Shala and others would help him if he withdrew his testimony. Before and after each of the 5 and 12 April 2023 approaches, the defendant, Sabit Januzi, communicated and coordinated with other group members regarding their interactions with witness 1. Mr. Januzi, Do you confirm your agreement on the agreed factual basis as I just read out to you?
Yes, I do confirm.
Thank you. I will proceed to read now, because paragraph 5 of the plea agreement refers to them. Paragraphs 8 and 9, 13 till 18, and 24, little I under I, double little I and 3 double little I of the confirmed indictment of 10 July 2024. I start with paragraph 8 of the 10 July confirmed indictment. And I will ask Madam Court Officer to pull both the Albanian and the English version on the screen. Thank you. Do you see it, Mr. Januzi? Do you see on your screen the text of the confirmed indictment?
Po.
Yes, I do.
Thank you. Paragraph 8 of the 10 July 2024 confirmed indictment reads as follows. On the 5th of April 2023, H.Shala called Januzi. Bahtijari then also called Januzi. Then we go to paragraph 9. Then, after calling and verifying that witness 1 was at home, Bahtijari came to the witness 1's home. Bahtijari told witness 1 that H.Shala had recently approached him and sent him to tell witness 1 that he should withdraw his testimony. Then we turn to paragraph 13. Later on 5 April 2023, after Bahtijari had visited witness 1, Shala and Januzi, and separately Januzi and Bahtijari, engaged in numerous text and phone contacts, including contacts between Shala and Januzi to coordinate an in-person meeting that same evening. And then paragraph 14. In the days that followed, Shala and Januzi, amongst others, remained in contact, including connecting by phone at least 4 times between the 6th of April and 9 April 2023. On 12 April 2023, we are now in paragraph 15, shortly after calling Shala, Januzi went to witness 1 home. At witness 1's home, Januzi told witness 1 that Shala had asked Januzi to follow up on Bahtijari's visit and to find out what witness 1 planned to do and how the matter of his testimony could be addressed. Specifically, Januzi told witness 1 that Shala had asked Januzi to convey the message that if witness 1 withdrew his testimony, then Shala and unnamed others would provide him with help. Witness 1 responded that if Shala and or the others brought him 200,000 euros, they would have a deal. And paragraph 17. Witness 1 did not confirm or deny being a witness. Januzi said he would tell them what witness 1 had said. Paragraph 18. Shortly after his 12 April 2023 visit to witness 1, Januzi again called Shala. And then paragraph 24, little I. On 5 April 2023, at Shala's direction, Bahtijari approached witness 1 and, little I, sub-little I, told witness 1 that witness 1 should withdraw his testimony in KSC proceedings. On 12 April 2023, at Shala's direction, Januzi approached witness 1 to follow up after Bahtijari's earlier approach and to relay the offer that Shala and unnamed others would help witness 1 if he agreed to withdraw his testimony. And then 3 little I's. Before and after approaching witness 1, Januzi and Bahtijari communicated and coordinated with each other and Shala. This was the content of the paragraphs in the confirmed indictment of the 10th of July 2024. I will now turn to paragraph 5 of the plea agreement, which states as follows. Sabit Januzi and the prosecution I will wait for a moment that we have the appropriate paragraphs in front of us. Thank you, Madam Court Officer. Sabit Januzi and the prosecution agree that if the prosecution were to proceed with evidence, the facts and allegations as set out in paragraphs, and I've just read them out to you, 8 and 9, 13 till 18, and 24, subparagraphs I under little I, double little I, and 3 double little I, of the indictment dated the 10th July 2024 would be proven beyond reasonable doubt, and that those facts are true and correct and not disputed by Sabit Januzi. Sabit Januzi retains the right to dispute any of the other facts or allegations contained in the indictment dated the 10th of July and any findings based thereon. Mr. Januzi, do you confirm your agreement with this statement that I just read out to you?
Paul.
I do.
Thank you. Mr. Januzi, the panel also wants to ensure that you are fully aware of the charges contained in the plea agreement. For that purpose, I will read out to you paragraphs 8 and 9 of the plea agreement itself, and also paragraph 3 of the plea agreement, because paragraph 8 refers to paragraph 3. Sabit Januzi, that is paragraph 3, agrees to admit guilt before the trial panel pursuant to Rule 94 of the rules in relation to counts 2 and 3 of the indictment dated the 10th of July 2024 to the extent they are alleging in count 2 obstructing official persons in performing official duties by participating in a common action of a group, between at least the 5th and the 12th of April 2023, punishable under the Kosovo Criminal Code, KCC, Articles 17, 21, 28, 33, 35, and 401, paragraph 2 and 5, and Articles 15, paragraph 2, and 16, paragraph 3 of the law on the Specialist Chambers and Specialist Prosecutor's Office, the law. And in count 3, intimidation during criminal proceedings by means of a promise or a gift or any other form of benefit between at least the 5th of April and the 12th of April 2023, punishable under the KCC articles. Then we go to paragraph 8, which reads as follows. Sabi Januzi fully understands that he is admitting guilt in relation to counts 2 and 3 of the indictment, as described above, and specifically admitting his conduct as set forth in paragraph 8, 9, 13 and 18 and 24, limited to subparagraphs I, under I, double I, and 3 double I of the indictment, and as further described in the agreed factual basis. And paragraph 9, which is also important for the nature of the charges you agreed on in the plea agreement. And paragraph 9 reads as follows. Sabi Januzi understands that if a trial were held, the prosecution would be required to prove the following elements of Article 21, 387, 401, paragraph 2 and 5, beyond reasonable doubt. And for count 2, that would be under A, participation in a group, which by common action, that's 401, paragraph 2, obstructs or attempts to obstruct an official person in performing official duties. This is the Kosovo Criminal Code 2019, Article 401, paragraph 2. The offense was committed against a judge, a prosecutor, an official of a court prosecution officer or a person authorized by the court and prosecution office or a police officer during the exercise of their official functions, which is the KCC Article 401, paragraph 5, and the element of awareness of and desire to commit the act or awareness that a prohibited consequence can occur as a result of the act or omission and accession to its occurrence. And this is the Kosovo Criminal Code, Article 21. And then for count 3, that would be under A, the element of the use of force or serious threat or any other means of compulsion, a promise of a gift or any other form of benefit, which is the KCC Article 387, and under B, to induce another person to refrain from making a statement or to make a false statement or to otherwise fail to state true information to the police, a prosecutor, or a judge, and such information relates to obstruction of criminal proceedings. This is, again, KCC Article 387, and as last element, awareness under C, awareness of and desire to commit the act or awareness that a prohibited consequence can occur as a result of the act or omission and accession to its occurrence. And this is the KCC Article 21. Mr. Januzi, can you confirm that you agree to the above charges?
Yes.
Thank you. Now, as regards admission of guilt, I will read out paragraphs 3 and 7 of the plea agreement, which is partly a repetition from what I just read out, but now in a different setting. Paragraph 3. Sabi Januzi agrees to admit guilt before the trial panel pursuant to Rule 94 of the rules in relation to count 2 and 3 of the indictment dated the 10th of July 2024 to the extent They are alleging that in count 2, obstructing official persons in performing official duties by participating in the common action of a group between at least the 5th and the 12th of April 2023, punishable under Kosovo Criminal Code, Articles 17, 21, 28, 33, 35, and 401, paragraph 2 and paragraph 5, and Articles 15, paragraph 2, and 16, paragraph 3 of the law on the Specialist Chambers and Specialist Prosecutors Office law. And in count 3, intimidation during criminal proceedings by means of a promise or a gift or any other form of benefit between at least the 5th and the 12th of April 2023, punishable under the KCC articles. Mr. Januzi, do you confirm your agreement on this point, that you admit guilt on those 2 counts?
Paul.
Yes.
Then we go to paragraph 7. Mr. Januzi agrees to make an admission of guilt in relation to the charges identified at paragraph 3 above, because he is in fact guilty and acknowledges his guilt and accepts full responsibility for his conduct as described in the agreed factual basis. Mr. Januzi, do you confirm your agreement on this point?
Paul, confirmoj.
Yes, I do confirm.
Mr. Januzi, the panel takes note of your agreement on this point, and we will formally ask you to enter a plea at a later stage during this hearing. Now we will go to the term of the plea agreement regarding the sentence. In terms of sentence, Mr. Januzi, I read in paragraph 11 of the plea agreement that you agree on the imposition of a sentence within the range of 24 till 30 months imprisonment. And the plea agreement also states in paragraph 16 that in exchange for your admission of guilt, the SPO will recommend to the panel a sentence within the range of 24 till 30 months imprisonment, and recommend that you be given credit for the time served in the custody of the Kosovo Specialist Chambers. And as per paragraph 16c of the plea agreement, the SPO also agrees to withdraw count 1 against you, Mr. Januzi. Do you confirm that?
Paul, confirmoj.
Yes.
Thank you. Let me now turn to paragraph 12 of the plea agreement, which concerns legal remedies. And as a preliminary remark, I note that the SPO has withdrawn its request for reconsideration and or leave to appeal of decision 612. This is filing 631, dated the 16th of December 2024. And as a result, paragraph 12 of the plea agreement is to be amended in order to conform to the decision 612. The panel will issue the necessary order in due course. I wish, however, to ensure that you understand how this impacts your plea agreement and that you agree with this change, Mr. Januzi. And you may, of course, confer with your counsel before you give your answer. Mr. Januzi, do you understand and agree that should the panel approve the plea agreement and set a sentence which accords with the terms of the plea agreement, you will be precluded from pursuing appellate remedies against said decision? And that you will not move to withdraw your guilty plea or appeal your conviction pursuant to your guilty plea. And I would like you to confirm that you understand and agree to both of the above points, Mr. Januzi. And you may, of course, confer with your counsel before you give your answer.
I would like to take brief instructions. Before I do that, can I just seek clarification in one matter? Paragraph 12A, as it's currently drafted, specifically refers to a judgment or sentencing decision which accords with the sentencing recommendation, paragraph 16A below. It may be that there's no difference between the terms that your Honour has just set out, which is set a sentence which accords with the terms of the plea agreement.
Yes, indeed.
If that's right, then I'm satisfied. The only reason why I raise it is because Your Honour will see that at paragraph 18C of this agreement at page 8 of 12, you'll see that specifically
Yes.
the right to appeal any reparations if imposed is retained.
Yeah. But do I read well, which is a rhetoric question, that between brackets you have agreed, the SPO and the defense for Mr. Januzi, if imposed in this case?
Yes.
The
So,
word imposed,
so
and our decision 612 clearly indicates that it's not on imposing.
oh, I see. So it's not setting. Imposing is different. Is that the point you're making?
Well, the point is making that this is an agreement between the parties and that the panel can submit for amendments what they want, but it's the parties who agree.
Yes, no, absolutely. But there's obviously a distinction between this is a sentencing agreement which deals with the sentencing recommendation that is in paragraph 16A, the range of 24 to 30 months imprisonment. What this agreement doesn't deal with is there's no agreement as to reparations other than the fact that it's a matter for you in due course. And the agreement specifically retains the right for Mr. Januzi to appeal against any reparations if in due course you oppose them.
If we would impose them.
Yes.
Yes.
Yes, thank you. Just wanted to get that clarification. Now I have, let me just take some brief instructions.
Defense counsel, you have conferred with your client. We
yes,
can
I have.
proceed.
You can proceed.
Thank you. Mr. Januzi, I would like you to confirm that you understand and agree to both of the above points. You have the floor.
Yes, I confirm. I agree.
Just to be sure, you understand and agree that should the panel approve the plea agreement and set a sentence which accords to the terms of the plea agreement, you will be precluded from pursuing appellate remedies against that decision. You understand that and you agree to that?
Yes, I understand that and I confirm that.
Question. You will not move to withdraw your guilty plea or appeal your conviction pursuant to your guilty plea. Do you understand that and do you agree to that?
I understand it and I agree with it.
So on the SPO side, I note paragraph 16 of the plea agreement, and the same preliminary remarks applies to paragraph 16b under A of the plea agreement with regard to the withdrawn request for reconsideration and or leave to appeal. Very well. Mr. Januzi, under Rule 94, paragraph 5, under C, the panel must be satisfied that you entered the plea agreement from your own free will. I note that in paragraph 24 of the plea agreement, you state that no one has threatened or forced me in any way to enter this agreement, and I entered into this plea agreement freely and voluntarily. And your counsel also submits in paragraph 25 that your decision to enter into this agreement is an informed and a voluntary one. Mr. Januzi, could you confirm before the panel that you have agreed to this plea agreement voluntarily, without threats or coercion?
Yes, Your Honor, I confirm that I entered this agreement without any pressure from anyone.
Let us move to the next point. The panel wants to confirm, Mr. Januzi, that you understand the consequences of the plea agreement and that you waive your right to be tried under the ordinary trial procedure as per Rule 94, paragraph 5 of the rules. On this point, Mr. Januzi, there are several steps and I will walk you through them. First, I would like to read out paragraph 17a till F and paragraph 18a till C of the plea agreement, as these paragraphs summarize the rights you waive and the rights you will still retain pursuant to the terms of the plea agreement. Mr. Januzi, by virtue of this plea agreement, you will be given up, in whole or in part, the opportunity to exercise the following rights. I start now with paragraph 17 under A. The right to plead not guilty and to require the prosecution to prove the charges in the indictment beyond reasonable doubt at a fair and impartial public trial. The right to be tried in your presence and to defend yourself through a specialist counsel at such trial. The right to raise defenses and grounds for excluding criminal responsibility and to present admissible evidence at such trial without prejudice to the right to make submissions and present evidence with regard to sentencing. The right not to be compelled to testify against yourself or to confess guilt. And the right to examine or to have examined the witnesses against you and to obtain the attendance and examination of witnesses on your behalf under the same conditions as witnesses against you, without prejudice to your right to examine any witnesses that may be called to testify, and your right to call witnesses and have them examined on your behalf at any proceedings with regard to sentencing. And the right to pursue appellate remedies with regard to conviction or sentencing as specified in paragraph 12 of the plea agreement, which I just read out. Mr. Januzi, can I have your confirmation that you understand this and you waive these rights?
Po e kuptoj.
Yes, I understand this, and I voluntarily waive these rights.
Second, pursuant to the terms of the plea agreement, Mr. Januzi, and I now turn to paragraph 18, it is understood that you retain all other rights, including in particular the right to be represented by specialist counsel at all stages of the proceedings and to communicate freely with such counsel in confidence, the right to submit any information or evidence relevant for the determination of the sentence pursuant to Rule 162 under paragraph 1 and 5 of the rules, and the right to appeal any reparations if imposed in this case. Do you understand that?
Po e kuptoj.
Yes, I understand that.
Before I turn to ask Mr. Januzi if he understands the consequences of the plea agreement and waiving his right to be tried under the ordinary procedure, I would like to give an opportunity, like we did this morning, to the SPO and to counsel to make any other observations or submissions they deem relevant, including as regards Rule 94, paragraph 5 under E and F, if they deem relevant. And I will first give the floor to the Specialist Prosecutor's Office, and then I turn to Defense Counsel. Madam Prosecutor, you have the floor.
Having listened carefully to Your Honor's colloquy with the accused, Mr. Januzi, it is the position of the Specialist Prosecutor's Office that the requirements of Rule 94.5 have been met, including parts E and F.
Thank you, Madam Prosecutor. Defense Counsel, you have the floor.
We endorse the same position. We note that the SPO in written submissions F00618 give further detail as to their assessment in relation to Rule 94.5 F in particular. We don't say anything further, but we adopt the same position that both sub-rules E and F are satisfied in this case.
Thank you, Defense Counsel. Mr. Januzi, having heard the submissions of the SPO and Defense Counsel, may I ask you to confirm again that you understand the terms and the consequences of this plea agreement and that you do not wish to change anything in this plea agreement that you have signed? You have the floor.
Po zonja.
Yes, Your Honor, I understand all the consequences, and I confirm the same.
You don't wish to change anything.
Nuk dëshira të ndroj asgjë po.
Yes, I don't wish to change anything to it.
Mr. Januzi, during the hearings of the 9th of October 2023, already more than a year ago, and 12th July 2024, you pleaded not guilty to the charge of obstruction official persons in performing official duties by participating in a common action of a group under count 2 of the confirmed indictment of the 4th of October, filing 10, and the charge of intimidation during criminal proceedings under count 3 of the confirmed indictment of the 10th of July 2024, filing 379, Annex 1, respectively. Are you ready to change your initial plea?
Po.
Yes.
We'll proceed to read out counts 2 and 3, and as reflected in the indictment of the 10th of July 2024, and ask you to enter a plea for each of them. And I ask you to stand, please. Thank you. Count 2. Obstructing official persons in performing official duties by participating in the common action of a group between at least 5 and 12 April 2023, a criminal offense against public order, punishable under Articles 17, 21, 28, 33, 35, and 401, paragraph 2 and 5 of the Criminal Code of the Republic of Kosovo of 2019, and Articles 15, paragraph 2, and 16, paragraph 3 of the law. Mr. Januzi, how do you plead? Guilty or not guilty?
Guilty. Guilty.
I proceed to count 3. Intimidation during criminal proceedings between at least the 5th and the 12th of April 2023, a criminal offense against the administration of justice and public administration, punishable under Articles 17, 21, 31, 33, 35, and 387 of the Criminal Code of the Republic of Kosovo of 2019, and Articles 15, paragraph 2, and 16, paragraph 3 of the law. Mr. Januzi, how do you plead? Guilty or not guilty?
Faitor.
Guilty.
Mr. Januzi, you may be seated. Very well. Before we turn to sentencing, I would like to discuss briefly reparations. The panel notes, Defense Counsel, that it's the view of the defense that reparations are not appropriate in the absence of any damage to or in respect of witness 1. This is filing 617, paragraph 37. Do you want to make any further observations, Defense Counsel, on this issue?
Yes, I do, and I was intending to address that as I make some more general remarks in relation to the prosecution's position for these hearings. I can do it if Your Honour wishes me to take that out of turn and deal with it now, or Your Honour can leave it to me and I will address Your Honours in due course on it.
I propose, if that would be possible, that you deal with reparations now, because in that way I will allow for the SPO also to give its views on the matter, and we can further exchange, if necessary, any submissions on the matter.
Indeed. So the issue of reparations is linked directly to the issue of harm. Article 22, sub-article 3 of the law provides that reparations are only applicable where a person has suffered harm which has directly resulted from the crime to which the accused has pleaded or been adjudged guilty. In this case, it is the offence, the two offences to which he has pleaded, which can only be relevant. The first offence is an offence directed towards the SPO. In the sense it's an offence of obstruction. There has been no suggestion made of any harm having directly resulted to the SPO from that offence. The second offence, the offence contrary to Article 387 of the Kosovo Criminal Code, the offence as pleaded to is encapsulated in the agreed factual basis. The first thing to say about the agreed factual basis is that it is agreed only that one person might properly be described as a victim of the offence, because it only refers to witness one being present at any point. Nothing else is agreed. In relation to witness one, therefore, and witness one alone, reparations would only be appropriate if it was established that witness one had directly suffered harm directly as a result of being offered help if he withdrew his testimony. There is no evidence to support any such conclusion. In fact, it is, of course, not even claimed. I'm going to deal at the same time, therefore, with the issue about harm, because it is the one and the two. Harm and reparations is an issue which is directly linked. At an earlier stage today, Mr. Devaney referred to evidence having been disclosed. Well, I think I know what he was referring to. He was referring to the witness interview transcripts of witness one and also witness W04981. At an earlier stage, Mr. Devaney might recall, I'm sure Your Honours will, that the prosecution had applied to admit the transcripts of witness one and W04891 as evidence in lieu of direct testimony. That application was refused. There has been no evidence from either witness one or W04891. In relation to the submissions that the prosecution makes about harm, you will see, if you look at paragraph 23 of the submissions F00618, and in particular at the top of page 8 of that document. I say page 8, it's page 9 of 23, page 8 of the substantive filing. But you'll see there that the prosecution made it perfectly clear that their view, as per the plea agreements, was that testimony was not needed in this case because, they said, the factual basis provided by each accused is clear and sufficient. And we absolutely agree with that. Have agreed with it. It is there in the agreed factual basis, as the prosecution have said today, provides everything that you need, require, and indeed have for the purposes of sentence under this agreement. I'm going to refer briefly back to the 17th of December further revised indictment this morning that we discussed this morning, because although Your Honours have decided to proceed by dealing this morning and this afternoon with Mr. Shala and Mr. Januzi, respectively, by going back to the 10th of July indictment directly, the further revised indictment that was filed yesterday, nevertheless, is of assistance because it does, as both prosecution and defence agreed this morning, reflect the content of the plea agreements. It was revised further in order to do that. Without taking you directly to the document, Your Honour noted this morning when Your Honour asked me directly why in particular paragraphs 11 and 19, as they appeared on the 6th of December revised indictment, there are equivalent paragraphs in the July 24 indictment, why they were deleted. The answer to that, together with the other amendments, is that they were deleted because it is no part of this case under the plea agreements that anybody suffered any fear or concern. So, for example, just bear with me for a moment, please. Any reference in indictment to a witness being caused fear or concern was deleted by agreement because any such fact does not appear in any of the paragraphs of either the 10th of July 2024 indictment to which Mr. Januzi has accepted, or indeed in the agreed factual basis annexed to the plea agreement. It was also agreed to delete any reference to any intention to intimidate a witness from the revised indictment, again because that reflected that the only intention, as per the plea agreement, is an intention to induce witness 1 to withdraw evidence or refrain from providing evidence in KSC official proceedings. And it was agreed also to delete any reference to pressuring a witness, witness 1, to recant his statement. That was agreed to be deleted because, in accordance with the plea agreements, the witness was not pressured but was instead induced. And it was also agreed to delete a reference to unwanted contact being had with witness 1. That's because the contact, in fact, was at the invitation of witness 1. Witness 1 having invited Mr. Januzi to his address on the 12th of April 2023 when he was present. He was present at the home address because witness 1 had asked him to attend at that location. So we say there is no evidence of harm, certainly no evidence of direct harm resulting from the offer of help being made to witness 1. And therefore, and in accordance with Article 22, reparations cannot be applicable in the absence of harm.
Thank you, Defence Counsel, for your submissions. I will now give the floor to the Specialist Prosecutor's Office. Madam Prosecutor, you have the floor.
On the subject of reparations, the SPO would propose to reserve making any submissions at this time, given the second oral order issued this morning, referring the matter to the VPO. And given that we will have a chance to respond once the VPO has identified any participating victims and issued a report, we would defer making any factual submissions along those lines until that point. At the moment, we're talking in the abstract, given that the VPO has yet to identify potential victims, accept applications, and then report back as to whether there are any participating victims and how many, as well as who they are.
Thank you, Madam Prosecutor. We know that. Then we go to Defence Counsel. You have the floor. I see that you're standing.
Yes, thank you. So, shall I move on to the issue of the material provided yesterday from the Central Criminal Record System of Kosovo?
I had another sequence in mind, but I will give you the floor. You will be able to put any submissions you want to put. We are going to discuss sentencing now, but please allow me to make some introductory words.
Indeed.
We will now turn to the defense submissions on sentencing. Mr. Januzi, I will have a question for your counsel, and if anything is unclear, you may always confer with him. Mr. Januzi, I will first now discuss with your counsel an issue with regard to your criminal record. Defense Counsel, the SPO submitted yesterday the criminal records of Mr. Januzi. This is filing 629, Annex 2. Do you wish to make any submissions in this regard, and should we go into private session in the affirmative? You have the floor.
I do wish to make submissions. In the first instance, I wish to record, note publicly in open session, that yesterday we received a certificate from the Central Criminal Record System of Kosovo, dated the 6th of December 2024, confirming, certifying that Savit Januzi has no conviction by a final judgment on his record. I would like at this stage then to go into private session, please.
Thank you, Defense Counsel. Madam Court Officer, could you please bring us into private session?
Your Honours, we're in public session.
Thank you very much. We note the parties' written submissions on sentencing, and in addition to the written submissions, I invite the parties to make any additional oral submissions or observations in court, and I noted that defense counsel for Mr. Januzi will do so, and I will after that give the floor to the specialist prosecutor's office. Please, defense counsel, you have the floor.
Thank you. I did want to deal directly with some of the matters that refer to harm, just dealing very briefly with that point, that appear in the written submissions of the prosecution. I'll give your honours the paragraph numbers, paragraph 48 and 49 in particular. But it does seem to me that in light of the prosecution's position this afternoon, that they make no submissions as to harm for these purposes, but they will wait to see what, if anything, arises out of the victims procedure that your honours initiated this morning. I take it that I do not need to deal with that today.
Defense counsel, I leave it to you. It's if you want to make submissions on this matter, I will note then, and if you don't, if you choose not to proceed in that way, that.
Well, I've referred the panel to those two paragraph numbers. You will see immediately the matters that I take issue with in there, and it's only really I would only be repeating what I've already advanced, which is that for the purposes of these plea agreements, there is no evidence, there is no admission, there has been no finding to the criminal standard based on admissible evidence of harm being established, and in those circumstances, your honours should not be taken down the wrong path, as it were, by those two paragraphs and other references to harm in the prosecution's submissions. We, of course, prosecution and defence have agreed an appropriate sentencing range. The bottom end of that range, the lowest end of that range is 24 months, and it is my submission that that is the appropriate sentence. It is the minimum sentence, albeit under Kosovan law, there is provision for a sentencing judge to go below the minimum. It's not actually a minimum sentence in that sense. You can go below it when there are particular features of mitigation that might justify doing that. But I accept for these purposes, I have done, it's there in the plea agreement, that the appropriate range begins with 2 years, 24 months. The highest end of that range, 30 months. My submission is that the appropriate sentence is that 24 months. The reason why I submit that is because there is no issue about this. The accused, Mr. Januzi, was acting under direction, whereas the prosecution have referred to there being multiple interferences with witness one. When they say multiple, they mean two. But in fact, for Mr. Januzi, he only had contact with witness one on a single occasion only. And the culpable conduct at the heart of count 3 is and only is the unspecified offer of help. That is the extent of the culpable conduct. It was not an offer of money. It was not an offer of an amount of money. It was an unspecified offer of help. There can be, in our respectful submission, no lower level of inducement for the purposes of the offence under Article 387 of the Kosovo Criminal Code. There cannot be a more vague, unspecified and lower level of inducement. Now, it's right that, of course, following that inducement being offered, witness one himself then requested a monetary sum. It was witness 1 who requested money, was not offered to him specifically, and he requested a sum of quite considerable amount. That was subsequently rejected, and there was no further attempt to induce the witness. It was suggested this morning by Mr. Devaney that this was a case in which the agreement was to stop witness 1 from giving evidence at all costs. That palpably is not correct, because it was the offer that he made to withdraw if he received €200,000 was rejected. And
Your Honours, we're in public session.
Thank you, Madame Court Officer. Defence Counsel, you have the floor again.
thank you, Your Honour. Obviously, this far, I've been concentrating on count 3, albeit that the conduct, which is the conduct that has been admitted to and belies the guilty plea to count 3, is also the same conduct that relates to count 2. But the consequences, or potential consequences, are different. With count 2, you are looking at the consequences in relation to the SC-SPO, or indeed, I say the SC-SPO, an official that is either of these specialist chambers or of the prosecution itself. And we make the point that there has been no suggestion, certainly nothing in the agreed basis of fact, but more than that, no suggestion that an act of either this court or indeed the Specialist Prosecutor's Office was in fact prevented or impeded or hindered or delayed in performing as part of his or her work with the Specialist Chambers or the Specialist Prosecutor's Office as a result of the accused actions. Those words are words that have been taken from the trial judgment in the case of Gazzetti and Haridinai when they identified what would be required to consider that obstruction had actually occurred as opposed to merely being attempted. This is, as Mr. Cadman submitted this morning, effectively a case of attempted obstruction. It was not successful in any way. Similarly, there has not been any suggestion that as a result of the diversion of time and resources, the SPO has been prevented from or delayed in carrying out its regular investigative functions. Again, those words taken from the trial panel judgment dealing with sentencing in the case of Gudzati and Haradinaj, case 07. In that case, the trial panel made the point that regular witness care, contact with witnesses, is part and parcel of what the SPO does on a day-to-day basis. And in this case, as in that case, there is no evidence, it certainly has not been proven nor admitted, that as a result of any diversion of time and resources, the SPO has been prevented from or delayed in carrying out its regular investigative functions in this matter. I won't take at any length, in fact, the list of aggravating features in Rule 1631B or Article 72 of the Kosovo Criminal Code. Safe to say that in our submission, none of those are indeed present in Mr. Januzi's case. In relation to mitigating features that, again, are listed, this time in Rule 163, Subrule 1A, Roman numeral 2, and Article 70, Subarticle 3 of the KCC, there are, however, a number of features that require a downward adjustment of the sentence. Firstly, there is entry into the plea agreement itself, and that is a specific, it's required specifically by the legislative scheme that fact requires to be taken into account as a mitigating feature of the case. I also say this, Mr. Januzi has not made a statement, but he has expressly given me instructions, as he did prior to the submission of this document, to express remorse on his behalf. He has reflected upon the time that he has spent in detention on remand, and he wishes to state publicly, through me, that he is remorseful for his conduct in April 2023.
Defense Counsel, do I understand well that Mr. Januzi is not willing, if we would ask him if he would like to express remorse, to say what you are saying in person?
Certainly, well, I can take instructions. Speaking in court is not something that comes easy to Mr. Januzi. It doesn't come easy to many defendants, and that shouldn't be held against him. As I say, I specifically had instructions from him to express sincere remorse on his behalf. I would not do that lightly. I do it because I am satisfied that that is a proper thing to express on his behalf, having discussed it and taken firm instructions about it. I can ask him if he wishes to confirm that he is remorseful. I suspect he would be very reluctant to say more than that, because speaking in court is not something that comes easy to Mr. Januzi. That is why, after all, we have specialist prosecutors that side of the court, and we have specialist counsel this side of the court, because speaking in court is not something that comes easy to people like Mr. Januzi. But I can certainly ask if Your Honour wishes me to.
Defense Counsel, let me put this straight. At this moment in time, the fact that you are expressing, that Mr. Januzi is expressing remorse through you, is not being held against him in any way at this moment in time. That is not the point.
But will it be taken into account in his favour?
But the panel, apart from having a specialist prosecutor's office and having a defense counsel, can ask, and there's no obligation, if the accused himself wants to say something about that, and if an answer would come, we could discuss that some more. That is a possibility. But this panel will not impose this on anyone, but I can ask you. That, and you can also say, we prefer not, you have given reasons, but I leave it with you.
You, of course, can, Your Honour. This is your court, after all, and you can address Mr Januzi directly if you not only wish, but also think it's fair to do so. Can I take instructions?
Defence Counsel, you may, please.
I think Mr Januzi's indicated that he's willing to assist you directly, if you wish.
He is willing.
He is willing to assist you directly if you wish.
Okay. We will first proceed with your sentencing submissions in order, and then we will go to that. Thank you very much.
So, just running again through the headlines, as it were, in relation to mitigating features which require a downward adjustment of the sentence. We do refer, we've already referred to the fact he has no relevant previous convictions, and we will also draw Your Honour's attention to elements of cooperation with his conduct with the Specialist Prosecutor and indeed the Specialist Chambers. Again, another specific feature to be taken into account. And then there are finally mitigating circumstances which relate to his personal circumstances that I will invite Your Honours to take into account. Again, requiring a downward adjustment to be made. Let me return then in brief form to those headline matters of mitigation. The fact of entry into a plea agreement. Not only is that a matter which is required to be taken into account, meriting a reduction in the sentence to be imposed. In this case, this was not a plea agreement that was made at the very last opportunity. In accordance with Rule 94.1, a plea agreement can be made as late as even the closing of the case. This plea agreement was entered into prior to the trial being opened. That is stated in Rule 94.1 to be the preferable time, and this agreement was made in a timely fashion accordingly. And it was done so further at a time when the prosecution, the only application to admit evidence by the prosecution had been refused. That is, the application to admit the interview transcripts of Witness 1 and W04891 in lieu of direct oral testimony. That was rejected by you, Your Honour. And there was also applications concerning disclosure failings alleged by the defence on the part of the SPO. So allegations that the defence brought pointing to disclosure failings on the part of the SPO. Those applications remained outstanding at the time which the plea agreement was entered into, and in fact they, as it happens, remain outstanding, of course, to this day. The fact of the plea agreements, and obviously in relation to Mr Januzi specifically, has saved significant court time and expense. And in my respectful submission, significant credit should be given for the entry into the plea agreement accordingly. In relation to the issue of cooperation, it is submitted on behalf of Mr Januzi that he did show an element of cooperation with the Specialist Prosecutor's Office at an earlier stage. That is, again, something to his credit. It began from the very outset. When he was first approached, an order had been issued ex parte for the Specialist Prosecutor's Office to attend at his address and carry out a search of both his home address and any vehicle that he had access to look for his mobile phone. In fact, what happened is that investigators from the SPO attended at the home address. Mr. Januzi willingly met them. They were not required to execute the search order against his will. On the contrary, they spoke with him, and he indeed voluntarily retrieved his mobile phone and handed it over to them without this search order being executed. He was, from that date in May, the 3rd of May 2023, obviously made aware that he was under investigation. It was part of the discussion the investigators had with him when they attended at his home address, and had been aware that he was under investigation since the 3rd of May 2023, right through to October 2023, when he, from his own steam, as it were, attended for an interview at the ULEX headquarters. Between May, when he handed over his phone voluntarily, and October, when he voluntarily attended for an interview, he was aware that he was under investigation and had remained in his home address, where the SPO knew where he was throughout. And when he attended at the ULEX headquarters for an interview, he attended and did give an interview. He gave a full interview, setting out a lengthy account. He, in fact, did so, even though he had been charged by that point by way of a confirmed indictment, albeit the fact that he had been charged was kept from him. He is, then, turning to his personal circumstances, a 58-year-old man. He has no relevant previous convictions. He is a former soldier. He fought during the war. Since the war, he's been a hard-working father and grandfather. He is a family man. He is a community man. He has very strong ties to his local community, the village of Upper Fushtish. He has lived and worked in that village throughout his life. He grew up there. He worked there. He continues to live there to this day. His home address was built by the family on the plot of land that they held in that village before his birth. It has been renovated, but only by the family themselves. He lives there with his 3 sons. Their details are set out in the submission, the written submissions that we've filed. His daughter, his 2 daughter-in-laws, and his 6 grandchildren, who age from being just shy of teenagers to being very young. Sadly, Mr. Januzi lost his wife some years ago when she passed away. He is a man of modest means, a bricklayer by trade, who works typically on small housing developments and renovations. He is not a well-learned man. He left education once secondary school came to an end. He works, again, as a family man with his 3 sons in construction. They are, he and his 3 sons, the tradesmen that he works with. In fact, at the time of his arrest, Mr. Januzi had not been working regularly because of poor health. In particular, he has advanced rheumatism in both his knees, which you'll understand poses a real difficulty for a bricklayer by trade. He has some other health issues also. The financial means, we've set out some details in paragraph 33 of our written submissions. They are, as I've already submitted, modest. The income from the family, the household that he lives in, is all pooled and effectively is then used to support that large household of 13 people. The household income will vary from month to month, as you could imagine, with a family team of tradesmen working in building, with work fluctuating and the income fluctuating with the work. But whatever is earned on a monthly basis across the household is effectively used and consumed in the living expenses for 13 people, 6 of whom are young children. The other 7 are adults living in the house. Mr. Januzi, one of the things that he has reflected on and greatly missed during his time in detention on remand has been the time that he spends with his grandchildren. He is a hard-working man, albeit with some health difficulties which make that difficult for him. But when he's not engaged in working, he is mainly, if not totally, spending time with his grandchildren. It is his utmost wish to simply return home, to be with his grandchildren again as soon as possible. We submit that taking all of those above matters into account requires the imposition of a sentence of imprisonment at the lowest end of the appropriate range, namely 24 months imprisonment less time served. Finally, we do additionally raise this matter. We do invite the court to consider a further order. We accept, and we have done it's there in the plea agreement, we accept that you will impose a sentence of imprisonment. But we invite you then to consider a further order that term of imprisonment imposed, we say 24 months imprisonment, the bottom end of the range, less time served, shall not be executed unless the accused commits another offence during a verification period of not less than 1 year. And that's the statutory verification period for the purposes of an order that the sentence shall not be executed under the Kosovo Criminal Code. It is within the court's discretion to make such an order. It's been considered previously by the trial panel 1 in the case of Gudzati and Haradinaj, and you have the reference there in the written submissions which referred to it. I can go through that in further detail if it assists, but it's there in the trial judgment itself. Moreover, it's within the court's discretion to do so, and in our submission would actually be a powerful tool to use in this case. That an order that the sentence of imprisonment imposed not be executed unless the accused commits another offence during the verification period would further the principles of rehabilitation. It would allow Mr. Januzi to return home to be with his grandchildren. He has already spent over 12 months in custody. He has never experienced anything like that before. And as is demonstrated from his expression of sincere remorse from me, it has had a salutary effect upon him. But it would also, such an order, further the principle of prevention, in that it would create a powerful incentive to him, if he was ever so minded. We submit that he is not, and we submit that you can be satisfied that he is not. But if he was ever minded to transgress again, he would have the powerful incentive of a term of imprisonment hanging over him like the sword of Damocles. I've already made submissions in relation to reparation, so I won't take any further time in that regard. Those are my submissions.
Counsel, thank you very much. We go to the Specialist Prosecution's Office, and I can give the floor to Madam Prosecutor. Your turn. Can you anticipate how much time you think you will be needing?
I'm going to try to keep it to 10 minutes, but I also ask that I be able to respond fully to my colleague. In the plea agreement, the parties have agreed to a sentencing range of 24 to 30 months imprisonment for Mr. Januzi. Specialist counsel has argued in his written submissions and just now before the panel for a sentence at the bottom of that range of 24 months imprisonment, or has invited the panel to impose a suspended sentence. It is the SPO's position that a sentence of 30 months imprisonment at the top of the agreed upon range to be served in prison would be just, appropriate, and necessary in this case, given the gravity of Mr. Januzi's crimes, including his specific roles and actions, as well as the importance of deterrence, even considering any mitigating factors that the panel might weigh in its ultimate analysis, as well as Mr. Januzi's admission of guilt, which I propose to address. Let me start with the offenses. The offenses to which Mr. Januzi pleads guilty, or may plead guilty, are serious. He committed the crime of intimidation during criminal proceedings. He and the other accused, as per the factual basis, targeted a specific witness. They coordinated to make 2 approaches to the witness in order to induce him to refrain from giving evidence before this tribunal. Mr. Januzi specifically was in close communication with the other 2 accused during the entire indictment period, and he personally approached the witness for the second approach that was made. Now, he acted at the direction of Mr. Shala, but he took it upon himself to address the witness in person physically. And in making that address, he referenced the first approach that had been made to the witness and that he, Mr. Januzi, was following up, therefore underscoring that his own efforts were part of a continued and persistent campaign to prevent the witness's testimony before this tribunal. And then he went further and communicated an offer of quote-unquote help from Mr. Shala and unnamed others in order for the witness to ultimately withdraw from the proceedings, or withdraw their proposed testimony as they understood it. Now, I do have submissions that I would like to make as to harm, completely separate and apart from the VPO process that will be undertaken pursuant to the panel's order from this morning. But I have a larger point to make about what facts the panel may consider in its sentencing analysis here. Now, we've heard from specialist counsel this morning and just now that what facts are before you are limited to what is contained in the Annex 1s to the plea agreements that the panel is considering, that is the factual bases. Now, the factual basis are the facts to which the accused are admitting in order for the panel to be able to find them guilty of the crimes of obstruction and intimidation during criminal proceedings. However, that does not limit the panel in its truth-seeking function and in imposing sentence. I will point the panel to our own rules, specifically Rule 162.1, which provides that the specialist prosecutor and the defense may submit any relevant information that may assist the panel in determining an appropriate sentence. This rule of our own has precedent in other tribunals, and specifically, I would refer the panel to the Babich case at the ICTY and the judgment on sentencing appeal, number 1807, or the date being 1807-2005. In paragraph 18 of that decision, the panel announced that it would exercise its discretion in determining the sentence on the basis of facts agreed by the parties, as well as additional information provided by the parties. Now, I make those submissions because there is evidence that was disclosed during the course of the proceedings, including witness statements, as referred to by my colleague across the aisle, that address some of the harm that the SPO would have sought to prove at trial. And I will mention that one of the facts referred to by my colleague was that monetary bribe that was raised in the context of Mr. Januzi's approach to the witness. I would ask that, should your panel consider that fact, which comes from these disclosed materials, that the panel not limit itself to just those materials, but also consider the various sources that are cited in the SPO's own sentencing submissions. That said, I will also point out that the panel has everything it needs on the basis of what is contained within the four corners of the plea and the factual basis contained therein or annexed thereto, to find that the only just sentence here is indeed 30 months imprisonment for Mr. Januzi. I will make one moment, I apologize. I also want to make reference, before moving on from this point, that Specialist Counsel also referred to another fact contained within the disclosed materials, but not in the indictment or in the plea agreement and its annex, which was that the contact between Mr. Januzi and the witness, that is the second approach as we've been calling it, was initiated by the witness. Well, again, in order to fully respond to that, I would have to refer, Your Honors, to the materials that have been disclosed and submitted by the SPO, because that, of course, is not the full story, just as the facts as laid out by Specialist Counsel with regard to the monetary bribe is not the full story. A witness statement sets forth in great detail how the second approach came about in terms of how it is that Mr. Januzi showed up at the witness's home, and also what drove the witness to address the monetary bribe referenced by Specialist Counsel. And so I would say that the panel should not limit itself, but rather abide by Rule 162.1 in order to consider whatever facts it should find necessary in order to impose a just sentence in this case. With regard to the harm, which is part and parcel of this analysis and the reference to additional materials, the reason I say that, even without reference to any disclosed materials, but based simply on the admissions contained in the plea agreement and made at these proceedings today, are sufficient for the panel, is that based on the facts that have already been admitted, it is, of course, entirely foreseeable, if not inevitable, that the result of the two approaches made to the witness in quick succession by two separate people would have the effect of causing harm, that is, placing the witness in fear. Now, that's not the only offense which we are here about today. There's also the offense of obstruction, and we submit that offenses against the administration of justice constitute a grave challenge to the security and integrity of judicial proceedings, including at this tribunal. These offenses undermine the discovery of the truth and impede justice for victims and for society as a whole. And the impact of these offenses, including specifically as part of a pervasive climate of witness intimidation that exists in the context of these proceedings, this tribunal, but also in the history of these types of proceedings in Kosovo, the impact cannot be overstated. That a protected witness at the KSC can be approached multiple times and subject to criminal inducement on top of that has a chilling effect on the public confidence in the effectiveness of KSC orders and decisions, including those related to protective measures. Turning to other factors that the panel may consider, I will note that Rule 163.2 indeed provides that an admission of guilt shall result in a reduced sentence, but that rule also provides that the timing of that admission shall be taken into account. The SPO's sentencing recommendation of 30 months in prison reflects the considerations in this rule. In the factual basis, Mr. Januzi has made only limited admissions. Those admissions came on the very eve of trial. That is, approximately 1 week before opening statements were set to commence. While those factual submissions entirely support and are sufficient to support the 2 counts being pleaded to today, they can also be fairly described as the bare minimum in that context. Moreover, Specialist Counsel made reference to 2 incidents that he proposes demonstrate the cooperative mindset, let's say, of Mr. Januzi. First, that when confronted with a search warrant for his phone, he offered it to him. Offered it to SPO investigators. But of course, it's hard to describe such an offer as voluntary when investigators show up at your door with a warrant, letting you know that they have a warrant for the seizure of your phone. So I would submit that the panel not attribute much weight, if at any, to that particular action on the part of Mr. Januzi. Moreover, the interview that he gave to the SPO cannot be considered meaningful cooperation in any sense. He admitted to visiting the witness, but he did not even approach making admissions of the kind laid out in his factual basis that provide the basis for his guilty plea today. Indeed, he attempted to obscure the core facts of his offenses, and thus that interview should have no mitigating effect on the panel's sentencing analysis. And so with that, given all of those factors, the SPO would argue that on balance, taken together, this panel should impose a sentence at the top end of the agreed upon range for Mr. Januzi, which would be 30 months in prison.
Thank you, Madam Prosecutor. Defense Counsel, you receive the floor again for any submissions.
Thank you. Just briefly, I would like to deal with the issue about what facts can be taken into account. The key phrase is facts. They have to be facts, not mere allegations. Facts can be either agreed, not in issue, or they can be proven to the criminal standard of proof on admissible evidence. They cannot, in any other way, enter the consideration of the trial panel. That does not mean, as perhaps I had not made myself entirely clear, it does not mean that all you can look at is the agreed factual basis. You can look at other information which, for example, is non-controversial and has and is accepted by all parties, such as the certificate from the Kosovo Criminal Records Bureau confirming that he has no recorded convictions on his record as of today's date. Other information, other allegations may be made by the SPO in the past. They may have been made by witnesses in the past, but where they are disputed, they cannot form part of your decision at this stage unless they have been proved to the criminal standard of proof on evidence that is put before this court. I remind the panel, and indeed the SPO, of the agreement that the SPO signed. Paragraph 5 of the agreement sets out, as Your Honour has very carefully gone through with Mr. Januzi, those paragraphs of the indictment dated the 10th of July 2024 that he accepts. And that he accepts would be proven beyond reasonable doubt. And that he accepts are true and not disputed by him. Paragraph 5 also goes on to make it clear that he disputes any of the other facts or allegations contained in the indictment dated the 10th of July 2024. It's there in the agreement that the prosecution signed and agree and proceed upon today. So you can refer to other information, such as, for example, character references in support of a defendant, or conviction from the Kosovo Criminal Bureau to the effect that the defendant has no relevant previous convictions, because those are matters that are not controversial and are not in dispute. But any suggestion that there was fear or even concern on the part of witness 1 is very much in dispute. And you haven't heard evidence from him, and you cannot, therefore, go behind the plea agreement to read into it something which has not been agreed by Mr. Januzi. It's not admitted by him. My learned friend describes what Mr. Januzi has accepted as the minimum, and that's right, and he's to be sentenced on that basis. That is what he accepts doing. He is remorseful for it, and he falls to be sentenced on the basis of it, not on other disputed, contested allegations that arise out of what can only be described as information and nothing more. Okay.
Thank you, Defence Counsel. I will give the floor to the Specialist Prosecutor's Office if necessary.
I don't have any additional submissions to make, Your Honour.
Okay. Thank you very much, Madam Prosecutor. Yes, then I have a question, or maybe more, for Mr. Januzi. Mr. Januzi, your counsel indicated, on behalf of you, that you have reflected upon your time in detention on remand, and that you wish to state that you are remorseful for your conduct in April 2023. And my first question to you would be, do you confirm this statement?
Yes, I confirm this.
Could you indicate to the panel why you regret what you did?
Do I have to stand up for this? Well, taking into account that my contact with the witness of the prosecution constitutes obstruction of justice, of course, I'm not happy with what I did, and of course, I'm not a legal person, but I regret what I did.
Would you do something similar again?
Now that I understand the importance of this matter, of course, I would never do it again.
So, if I understand you well, you're saying to the panel, but please correct me if I'm wrong, that you consider that your behavior was wrong.
Paul.
Yes.
Mr. Januzi, this suffices for the panel. This was the last part of the plea hearing with regard to the plea agreement of Mr. Januzi with the Specialist Prosecutor's Office, unless there is anything that the Specialist Prosecutor's Office or Defense Counsel want to raise. And I see a nodding from the side, a nodding in the sense, no, there's nothing to raise from the side of the defense, and
I have something more akin to a process. I have something more akin to a process proposal with regard to the further amendment that needs to be made to the plea agreement. I understood from the plea colloquy between Your Honor and Mr. Januzi earlier that the panel foresees requesting further amendment to paragraph 12 of the plea agreement, and I wondered if it might not be possible to make those changes to the plea agreement now in handwriting and initial while we're all here, just to avoid the kind of drawn-out timeline that may result in trying to just coordinate between the parties and then also with the DU in order to execute a new agreement. So just wanted to put that out there in case the panel would be amenable and in case Specialist Counsel and the accused would be amenable.
okay. Defense Counsel, is there, and I will give in this, but this is, your remark it's not only, it has not only to do with the plea hearing we are concluding now with regard to Mr. Januzi, but I hear you that it's for the three plea agreements.
Yes, indeed, if possible.
Okay. But then let's get things straight for the record. We have concluded the hearing, the plea hearing with regard to Mr. Januzi, yes, and we are now considering a proposal made by by Madam Prosecutor with regard to any further amendments to be possibly made to the plea agreements. I will invite the defense counsels of the three accused to give their views on that, and then we will proceed. Defense counsel, you have the floor.
I'm conscious that we will have some time tomorrow. Whereas I certainly join the exhortation for us to be able to deal with this promptly, rather than deal with it now, perhaps we can agree what the terms are to be amended, and then I can deal with getting Mr. Januzi to sign and explain to him anything that he's been asked to sign tomorrow morning.
Very well, thank you. Defense counsel for Mr. Shala.
Your Honor, I'm conscious that Mr. Shala is not going to be here tomorrow, but I feel as though it's probably not quite as quick and simple. It's going to take a little bit of time, and I obviously don't want to see Mr. Shala waiting in the cells downstairs for the next hour whilst we're trying to organise this. I think it probably is better that we agree what changes need to be made, and then we make arrangements in order for it to be signed tomorrow.
Good. The Defence Counsel for Mr. Bahtijari. You have the floor.
I do apologise, I'm sorry. I'm sorry, would you ask me the question again? I do apologise.
Yes, if you agree or not, or what your submissions are regarding the proposal of the Madame Prosecutor, but maybe you missed that.
I didn't think it applied to Mr. Bahtijari because he will be here tomorrow. I can't see him overnight, so anything that needs to be signed we can deal with tomorrow. My request for tomorrow was to come in the morning.
That we are not going to discuss, as now we are first going to discuss the proposal made by Madame Prosecutor with regard to the plea agreement. But
yes, I thought we were discussing the signing of a plea agreement. I can't do that today.
No. Amendments to the plea agreement.
Yes.
Okay.
I can't do that today because he is not here. You've ordered for him to be here tomorrow, so I'm sure we can deal with it tomorrow when he is here.
Thank you for your submissions.
That's why I thought you weren't asking me, was because he's not physically here today and the other two are. Thank you.
Very well. What we will do is, this could be an idea. I see the usefulness of the idea, but it's very possible that further amendments would be needed. So whatever, if there would be an agreement to take out any paragraphs that now, in the light of what we have discussed and in light of the withdrawal of the request for reconsideration or the leave to grant an appeal against the decision 612, it could be that there are still further issues that need to be discussed. So parties are free to agree that parts of their plea agreement don't apply anymore, but that will not refrain the panel to propose any further amendments to this agreement. So that would be for now our position. Madam Prosecutor.
Thank you, Your Honor. I made the proposal based on an understanding that the changes would be limited to paragraph 12. So rather than executing amended agreements in further rounds, perhaps it makes sense to hold off until the panel reaches a decision as to all the changes.
Okay. Madam Prosecutor, at the beginning of our of the trial this morning, our instructions or our planning as how to proceed also included that the panel may give further instructions in this matter. So yes, it could very well be large, but I'm not in a position now to say anything on that. We first have to further deliberate. Very well. So then we go to a pending request. Before we conclude today's hearing, the panel notes a request of the defense for Mr. Bahtijari. No, I already have your request. So to start tomorrow's hearing as regards the plea agreements entered between the SPO and Mr. Bahtijari in the morning in order to maximize available time. And said request was communicated to the panel today via email at 14:54. The panel is confident that there will be sufficient time to go through the terms of Mr. Bahtijari's agreement and related matters during the afternoon session, and therefore we reject your request, and we will start at 1 o'clock as indicated in our scheduling of this morning and in our oral order. So this concludes the oral order of the panel. Is there anything else parties would like to raise with, I see you nodding, and SPO, would there be anything you would like to raise just to know what? No, I will give the floor first to Mr. Rees, but is there something you would like to raise later on?
Nothing further today, Your Honor.
Very well. Mr. Rees, you have the floor.
Thank you, Your Honour. Just one brief matter. It is a request in relation to reclassification. Your Honours previously gave a decision on matters related to plea proceedings, filing F00612, which was intended to regulate, as it were, the process that has led to today's hearing. As part of that, the filing did come with a confidential and ex parte annex with a direction to the Specialist Prosecutor to provide by the 6th of December submissions on the matters specified in the annex attached to the present decision. And that was again repeated in the disposition. As we are now, as it were, past the plea proceedings hearing in relation to Mr. Januzi, although we are continuing tomorrow with a third defendant, my request would be for the court to consider reclassifying that annex and indeed any submissions responding to it that were submitted by the SPO pursuant to F00612 in the event that the defence may wish to make, they may not wish to, but they may wish to make some submissions in relation to the content of it. Obviously, I don't know what the content is because at the moment it's ex parte and the only party that's seen it is the prosecution. I infer from the direction that they make submissions on it. But I would request that the court considers reclassifying that because it was part and parcel of the decision that regulated these plea agreement hearings, and it does seem to us that the defendants ought to be entitled to see both the request and the submissions pursuant to it from the SPO. That's my request.
Thank you, Defence Counsel. Specialist Prosecutor's Office. Madam Prosecutor.
With regard to that specific...
Sorry, we can remain in public?
I won't address the substance, but I will address the role of WIPSO.
I cannot foresee what you are going to say, so
yes.
It's for you to ask the panel if we have to go into private or not.
I think we're fine in public session.
Okay, good. Then we proceed.
Okay. What I will say in public session is with regards to the annex, we do not support its reclassification. It is concerned with witness protection measures, and certainly it is not only our submissions that should be sought before seeking reclassification, but I would submit also possibly WIPSO in connection with the contents of that annex.
Okay, thank you. Defence Counsel, is there anything you would like to add in this respect?
Yes, only this. I'm grateful to my learned friend for the indication as to at least the nature of this material. That's something that we didn't have any information at all about it. And whereas we do accept it is part and parcel of the legislative framework of these chambers that ex parte communications between the trial panel and the SPO, and also other parties if necessary, is part and parcel of that framework. I would always encourage, where possible, even if the document is not reclassified, there is a description given of the document so we can at least understand potentially why it might have been classified in the way that it was. So I would urge, if reclassification cannot be made in full, whether there can at least be either a redacted version, or indeed, if not a redacted version, a document to summarise what the document contains, so that we can at least understand why it was ex parte, and there is no suggestion from our side that you've been shown something that materially affects this procedure as far as the rights and entitlements of the defendants are concerned. That's simply all.
Thank you very much. Do the other defense counsels want to submit anything in this regard?
Having discussed the matter that Mr. Rees has just set out with him earlier, we support the application that he now makes. And certainly support that, but no further matters that need to be raised at this stage.
Give you the floor, Madam Prosecutor, but I first want to be sure that we have taken all the submissions on board from the part of the accused defence.
Thank you. Having heard what we've heard from the SPO today, I think what we would ask for is a filing that just sets out the categories of what's been left as ex parte, because we've just been told that category. So we would invite a further filing that just clarifies that particular document, and maybe further reflection to change the classification. Without us knowing the content, it makes any further submissions difficult. So I think I sit somewhere between both sides.
Your submissions are noted. Thank you.
Thank you.
Madam Prosecutor, is there anything you want to add before I indicate what will be the course of action? What will be the course of action of the panel?
I wanted to request that we actually deal with this matter in written submissions, because I'm not entirely comfortable when it comes to this type of material kind of responding off the cuff in the way I just did, and I'd like a chance to be a more deliberate and maybe come up with a better proposal in terms of something responsive to the concerns that have been expressed by defense counsel today. So I would make the proposal that we perhaps shift this to written submissions.
The panel will come back to this tomorrow. If necessary, we will give an oral ruling, and we try to sort this out in a way that takes on board the concerns and also the issue of confidentiality. I see Madame Jerry, of Defense Counsel Jerry, raising her hand. You have the floor.
Just very quickly, I've made a suggestion, not a request, via your court officers, in an attempt to assist in the carriage of your questions to Mr. Bahtijari when he's here tomorrow, that they are kept as simple as possible, perhaps without the lead-up of the section numbers and so forth. I've written that down in a document just for your assistance. I'm not making a request, I'm not asking for a filing, but I've made a suggestion that you might want to do that and perhaps have a copy translated for him. I don't think it's for me to start giving him your questions in advance or anything like that, but I just hope it's helpful, and I didn't want it to come as a surprise before you rise. You can completely ignore me and, of course, conduct your court in its own way, but it's a suggestion so that we can get through matters swiftly tomorrow. Thank you.
We have taken note on this request, suggestion, how you would like to formulate it, and we will relay instructions to you as soon as we have had the time to fully consider it outside this courtroom.
Very grateful. I just didn't want it to not be aired when you asked if there was anything else. Thank you.
Then, this concludes today's hearing. As announced earlier, we will reconvene tomorrow at 15:30 in the composition with the three accused and the defense lawyers, and not all accused will be present, but we request the presence, of course, of all defense lawyers. We will have at 1 o'clock, as indicated earlier, the plea agreement hearing with regard to Mr. Bahtijari and the SBO. And this wrap-up session for all parties will be around 3:30. However, it could also become later. We start at 1, and let us see how we proceed. It could also become 4 o'clock or 4:30. We've seen that there has been a little bit of difference between Mr. Shala's duration of the discussion of the plea agreement and of Mr. Januzi. Very well. Then I would like to say that I thank the parties for their participation in today's hearing. And I also want to thank the interpreters. I didn't ask for the possibility to work longer, but it was all arranged for our audiovisual technicians and the security personnel for their assistance. The hearing is adjourned.
All rise.